ಮೇಡಮ್ ಅದು ಮಾಡ್ಕೊಬೇಡ್ರಿ, ಈಗ ಹೋಗುತ್ತೆ ಅದು ಮಾಡಿದ್ರೆ.
Page number 8, seal number 29 to 31. Page number 30 to 37.
It is settled. Kindly post of 2 weeks. And the stay may can be extended.
It is submitted that the matter, have you informed the other side?
Yes.
It is submitted that the matter is settled. They'll come up with an appropriate memo. This is matter after 2 weeks.
Stay may can be extended.
And tomorrow earlier granted. The extended till then. Yes. 35. Then council submits the improved order is in Kannada for filing the translation. This is matter on December 16th.
Series number 34, my lordship.
20?
34. I'm for petitioner, my lordship. My senior colleague is not feeling well. Sorry for me.
It's coming up for the first time before me?
Yes. Yes, my
Or it has come up last week also, before week also? It is submitted with the council is not feeling well. This is matter on 13th of November. Yes.
Page number 10, seal number 38 to 43. Page number 11, seal number 44 to 48. Page number 12, seal number 49 to 54. Page number 13, seal number 55 to 61. Page number 14, seal number 62 to 67. 60.
Sir? At the request of the council for the respondent, list this matter on 9th of December. Yes.
Page number 15, seal number 68 to 79.
Seal number 68. I have petitioner, my lordship. I think 2 weeks time.
68 or 50?
Please, 68. I inform.
Why you want adjournment?
I inform the sir. Yes.
No, why do you want
My personal
adjournment?
interest.
This is matter on at the request of the council petition on 16th of December.
77 also.
Why all the matters have to be adjourned? Same day. Yes.
Page number 16, seal number 80 to 87.
You file today. This is market after tomorrow, ready for. Yes, at the request of the council respondent. Have you informed the other side petition also? Please inform and make mention every time because they have to wait again if you don't inform them. Yes, next.
Page number 70, 88 and 89. seal number
This 89, I pay for the petitioner. There is a connected petition, land reforms matter. The order of the land tribunal, which is granted in favor of the petitioner, is also got in question by the very same party who has filed a suit. In fact, last occasion when the matter was heard, the Honorable Court has asked them to file a memo to get it clubbed. The memo was not filed by them. I shall file it in the course of the day because this will have a bearing on that petition also.
Which writ petition?
I shall give the number.
Then let this be listed along with that.
Yes, I shall.
What is the number? Give the number. List this matter along with so and so after obtaining necessary orders from the Chief Justice. Yes. List this matter on along with that matter. List this matter, both the matters on 13th of November. You appear for the petition.
Petitioner.
What's the personal inconvenience today?
Some.
You are here in the court. I can understand you have not come to the court. 74 at the request of counsel, the petition is this matter on 11th. No further adjournments.
Please,
in all the cases where a interim order is there extended.
Notice 26, I am permitted to withdraw the not.
20?
26 months.
Write a memo and give. Then 26. Then council, a memo is filed. So the petition will be dismissed as not pressed. Say memo is taken on record, and the petition is dismissed as not pressed. Take that memo from him. Yes. Next.
My lords, serial number 71, my lords.
Hmm.
My lords, there are 4 matters today listed, my lords. We are physically appearing tomorrow, my lords. Kindly have this matter tomorrow, my lords. 4 excise matters with petition. Serial number 6.
Every time.
My lords, last date, my lords, the sitting was cancelled, my lords. We are already booked the ticket, my lords, because of the non-sitting, my lords.
Tomorrow, list all these matters tomorrow.
My lords, 66, 67, 71, and 83, my lords.
Yes.
I apologize, my lords. Sorry, my lords.
Yes.
Yes.
Please, my lords.
Yes.
Page number 80, serial number 93.
Serial number 92, my lord. Serial number 92, my lord. A paper I will come to the first session.
Why time?
Because the pleadings are all in Kannada. I have to find the translated copy, my
Submitted
lord.
that
And interim state
the include order is in English.
in English, my lord.
Then it's fine. Doesn't matter. Court can understand.
Yes, ma'am. Anyway,
Not 2 weeks. Does this matter on 11th November?
interim order may can.
It's a more earlier granted is extended till then. Is next
Serial number 90, they are for petition.
90. Huh.
Inform other side. Next week,
So why did 2019 matter be adjourned today?
first time, such and such.
This also on Monday, no further adjournments will be granted.
Please.
Which one? Huh. This also on Tuesday. At the request of, have you informed the other side? At the request of the counsel for the petitioner. Yes, next. 60.
Collected with petition, Your Lordship. I'm appearing on behalf of Kirin advocates, Your Lordship. May I request next week, Your Lordship, to not be able to meet.
We'll see. We'll see when the matter reaches. Yes, next.
41. Seek upon serial number 41. 41. Apply for petitioners, apply for 2 weeks time. There's a marriage in a senior home. Because of that.
When is the marriage?
Yeah, tomorrow.
Then why 3 weeks? We'll have it on 14th November
Please.
at the request of land. Inform the other side
Please, already informed.
at the request of land counsel petition. Yes.
Page number 90, serial number 94 to 99.
97, my lord. He is out of session, my lord.
97 at the request of land counsel petitioner. This is matter on 12th. No further adjournments will be granted. Yes.
Serial number 95. Godela. He is out of session.
Day after tomorrow. At the request of land counsel petitioner. Yes.
This number 1, all smart, serial number 1, vide document, they can be back.
Fifth.
At what time is it? Yes.
Memo for retirement filed by Shri Divya Kachin.
Memo
for retirement filed by the Divya Kachin at Maharashtra.
Memo for retirement filed by so and so for having served notice on memo of retirement. Where is that?
28/8/2023. 28/8/2023. 24 Maharashtra.
When was it served? When was it sent? When was it served on the respondent? Where are the dates? File that memo also. File that acknowledgement, whether it is served on him or not. The petitioner shall serve shall place before the court the acknowledgement that having whether the petitioner had received received the notice sent by the advocate. List this matter on 12th of November. Yes.
Number 2, another day.
As per the directions, I have served the copy to the counsel who appears for the respondent number 4. That in 5 minutes, the memo in the registry. I would like to bring it to the notice report that one of the contestant respondent died. I have secured the instruction with the death certificate also. It's 2 weeks time. I'll file a memo.
Who died?
Co-defendant.
Huh?
If I may be permitted to submit my lords, I am appearing on behalf of the plaintiff before the trial court. Who is the contesting respondent? The rest all are the co-defendants.
Because they say is also very much important because
What's the suit for?
so suit for partition and separate possession, filed by my brother. That's against two brothers. That's my contention.
What is the order impugned?
That's the application which was filed by the present petition.
7 Rule 11.
For the trial court for the application was 7 Rule 11. The rejection of the plaint was rejected. Against that,
We will see what is at first. Then we will go to the other things.
Since the other defendant who died,
There's a stay.
they are necessary part.
83
Because they say it's also very much important. But I'll request. I'll file a necessary application.
Lords, you may bring the LRs of the deceased respondent. A date may be fixed, my lords. That is
Date
the only
may be
place.
fixed, my lords. I'll file a-
83-year-old petition plaintiff. That is the only.
The second respondent died on 21/9/2023. I have the details of the LRs of the deceased person. One wife, one son is there. I'll bring them.
No, a 2018 suit is stayed, suit of which year? 2016 suit stayed in 2018. After 6 years.
I will not say that I will not seeking any adjournment. I file a necessary application. Let them court may pass an order. I will ready with the matter. Let the matter may be disposed of.
20th, my lords. Anyways,
This is matter on 20th.
please.
By the time the appropriate application shall be filed. Now again, notice has to go.
I'll file it. I'll file it today or that tomorrow.
List this matter after.
I will be permitted to file application in the counter registry. I'll file
List
it.
this matter after a week.
Please.
At the request of non-counsel of the petitioner, we shall come up with
As
an.
per the direction also, I am filing memo to the effect that I have served a copy on the.
Yes.
The interim order is there.
Interim order earlier granted is extended.
Number 3, Vitala Sundari.
Lords, date. Date.
It will come next week on 12th.
Please.
Yes.
For a week's time to take a step in respect of respondent number 7.
When the respondent number 7 died.
During the COVID.
This is coming from 19/11/2021. We'll dismiss the revision as far as R7 is concerned. And we'll proceed with the matter. Why? This court has directed on 19/11/2021. On 19/11/2021, it was recorded that the respondent number 7 died as per the postal sheriff, and till then, from there till now, no steps are taken in respect of respondent number 7. The petition, as far as the relief against the respondent number 7 is concerned, is dismissed. This matter on 13th. No further adjournments will be granted. Yes.
Number 4, Manisha.
Yes.
For 2 days.
What steps? When R4 died?
The notice was issued minutes.
Huh?
The date of death is not known minutes. We verify minutes and take steps minutes.
Postal Shara. This is
And it
When is the
cannot-
postal shara?
15/12/2022.
15/12/2022. What steps you will take now? And what you are not, why you are not taking steps?
Minutes will
Is there
file
any stay in this?
We'll file application for bringing LRs and setting aside of the engagement minutes. In respect of responding number 4,
No, there is no interim order in this. What is the revision? This is a revision of 2019. What is the interim order? Where is your senior? You argue or your senior?
my senior would.
Ask him to come. Ask him to come. Pass over. Yes, next.
Seal number 5. Seal
Take that.
Well, R23, I seek for dispensation of issuance of notice because they had remained absent before trial court and.
So with this, the process is complete.
Yes, sir.
Then please argue.
This petition is filed by the defendants.
Where is that? Take that memo first. A memo is filed seeking dispensation of notice to respondents number 2 and 3. The same is taken on record and the notice so and so is dispensed with the risk of appellant. Yes, next.
This is a petition filed by defendants, wherein the suit of the plaintiff defined respond number. The respond number 1 will be service in the head section because he has refused the notice.
As far as R1, notice to R1, returned with the postal share refused, amounts to deemed service of notice. Yes.
Partition suit filed by respond number 1 is decreed for 1/5 share.
What?
1/5 share.
Your
I have for defendants.
number?
1 and 2. They filed appeal. They, defendant number 1 and 2 along with respond number 3 here. They filed appeal. Appeal was allowed with the condition that the defendant appellants they have to file deposited cost of rupees 3,000 before the trial. That was not deposited within time. Therefore, the petitioners filed application before appellate court seeking for extension of time and permission to deposit the amount. That is rejected.
And what has happened in this CRP?
In this CRP, this notice is the service of notice is now.
Then what is? Then why are you not pursuing? Why have you not pursued? From
I want to
2009?
pursue my lord. I filed application before appellate court, but the appellate court rejected.
No, about for hearing of this revision.
Ready, madam.
It's not about ready. When is the decree?
Decree is of 1/2017.
2017.
Appellate court decreed the allowing the appeal on 25/9/2018.
And you don't pay the amount. A conditional order is not fulfilled. Why should the court do it now?
Yeah. Four persons, sorry. My lord.
No, why? If you're interested, you should have done it.
Please, my lord. Other instances, they could not deposit the amount within time.
What is the amount?
3,000 rupees was allowed. Partition should earlier partition like there were also that I have created and want to file a appeal. Appellate court allowed, but to some inconvenience they could not deposit the cost within time. If Lord's grants me, I will.
No, that's what I'm asking. Why should the court show indulgence when your client is not vigilant? Already you suffered a decree. Appellate court had come to your rescue, passed an order. You don't do anything. So right from now there is no interim order.
No.
So the final decree might have been
No, not at all.
final decree might have been passed.
Not at all. Final decree proceedings are not concluded.
A place that the proceedings, the court proceeding,
Before
the
the-
sheet of the trial court. What is the stage of this? Executing court.
No, final decree proceedings. Please,
Final decree proceedings.
please, ma'am. 1 week time. 1 week time.
List this matter on 12th as partnered
Please,
on the top of the list.
please.
Yes. By the time the counsel for the petition shall place before the court the proceedings before the executing court, what is the stage of proceedings? Yes. Yes.
2 days. next steps with respect of respond number 3. And so respond number 7 has been made by necessary application.
What is the impugned order?
Page number 24. Petition filed with petition under order 20 to 18, that is section 151 is hereby dismissed.
Is it at page number 11? Application to reopen the final decree proceeding. Let's read the order.
I'll read.
Please read the order.
The petitioner has filed this petition under Article 20, Rule 18, that is section 151 CPC, requesting the court to reopen the final decree proceeding held in decree number 5 of 2011 and modify the final decree or proper another decree if necessary in the interest of justice and equity. He has contended that the legal heirs of opponent number 1 have obtained a final decree by playing fraud on the court and without bringing the deposit adopted son of Satava on record. The adopted opponent number 1 has made misrepresentation to the court by stating that the defendant number 2 died without any issue. He is the adopted son of Satava. The decree passed in decree number 5 of 2011 is not sustainable since the same was obtained by misrepresentation. The share of the deceased defendant number 2, Satava, was not adjusted, but the final decree was passed without passing any orders in respect of her share. The deceased opponent number 1 is entitled for 1/9 share as per preliminary decree in all the two properties, but an extent of 1 acre 4 guntas in RS number 98/2 property was allotted to her share, which is more and valuable land. The court commissioner has not submitted his report in respect of house properties. Hence, the final decree is not sustainable, which requires modification or to pass another decree. Accordingly, he has requested to court to allow the petition in the interest of justice and equity. Respond number 7 before the trial court replaced ex party. Respond number 3 is a contested party.
Yes, what's wrong with this order? You say that the decree is obtained by playing fraud on you, and you want the final decree to be amended or drawing a separate decree. How is it permissible? When you say that it is obtained by fraud, you are at liberty to question the said decree, that it is not binding on you. Court has rightly held so. And that decree cannot, that court cannot now again lead all the evidence with regard to fraud and other things, and no, it can't give a finding on that. It has to be by way of a separate suit. Please come. The present revision is filed, agreed with orders passed and civil miscellaneous number 19 of 2015, dated 30th July 2020. The petitioner herein has filed this petition, has filed the petition seeking the requesting the court reopen the final decree proceedings passed in FDP number 5 of 2021 and modify the final decree or prepare another decree if necessary in the interest of justice and equity. According to the petitioner herein, he is the adopted son of Satava. The respondents have made misrepresentation to the court, stating that the said Satava died without any issues, when the petitioner herein is the adopted son of Satava. Hence, it's a case of the petitioner that the said decree that's obtained by the respondents herein is by playing fraud, and the same is not binding on him. Hence, he has come up with the instant application. The court, having considered the respective pleas of both the parties, has come to the conclusion that the fraud vitiates everything, and the petitioner has every right to question the said judgment and decree by way of a separate suit. In these proceedings, the court cannot decide all these issues. In fact, it has to seek a declaration and also prove that he is the adopted son of Satava. Considering all this, the court has dismissed the application filed by the petitioner and all 22 Rule 18, let's say read with section 151 CPC, and also gave the liberty to file a separate suit by seeking declaration in respect of his adoption and then claim the share of defendant number 2, Srimati Satava. Agreed thereby, the petition is before this court. Lead counsel appearing for the petitioner submits that the court, when by playing fraud, when a decree is passed by the court ought to have considered all those issues and ought to have passed a final decree. It is submitted by the lead counsel that the court has failed to consider the application of the petitioner in its proper perspective. Next one. Having heard the lead counsel petitioner peruse the entire material on record, a final decree proceedings, or that is an FDP number 5 of 2011. Now it's a case of the petitioner that the fraud is played, and it is not brought to the notice of the court that defendant number 2, Satava, has an adopted son. That's a petitioner hearing. As such, a new final decree has to be drawn. On the face of it, the contention and the application cannot be entertained as entertained. The relief that the petitioner is seeking is that the said decree is a fraudulent decree and is entitled for share, being the adopted son of deceased Satava. The factum of the adoption has to be proved, and then you can seek for the share, and also that the said decree, final decree proceedings, or the final decree that is granted by the court is not binding on him. And that can only be done in a suit that is in a separate suit that has to be instituted by the petition hearing, but not by way of an application filed under Order 20, Rule 18, that is Section 151 CPC. Next one. In the considered opinion of this court, the trial court had, the executing court had considered all these aspects and rightly dismissed the petition, giving liberty to the petitioner to file a separate suit. And this court finds no reasons to interfere. Accordingly dismissed.
On number 1 is concerned, Lord, it says acknowledgement is not at received. I'll take steps to Lord.
First, let's see the order.
7-11D application is rejected. Only
Let's see,
down-
let's see, let's see. If there is any point, then we'll wait for the notices. If it is not, we'll pass out.
The only ground on which we have sought for rejection of plaint is that granddaughter claims share in the property which stands exclusively in the name of grandmother, and that too during her lifetime. The only ground is under section 15, succession opens only on death of a Hindu female, and till her death she holds it as its absolute property. Therefore, at this stage, suit is premature. That is the only case.
Interim order is there in this.
No, my lord.
The suit must have been proceeded.
No, 611, I filed an application seeking to file my written statement before the trial court. 611, it is posted for hearing on the objections are filed by the plaintiff. It is still in the stage of hearing on that IM. 611.
Let's see what's the order of the court.
One submission. I'm sorry, my lord. There's some issue with the file, my lord. That is the reason.
Tomorrow?
Tomorrow, my lord.
This is matter tomorrow at the request of front counsel for the petition.
Okay.
Yes, next.
Seal number 8. RHND, seal number 8.
No representation. This is matter for dismissal tomorrow.
Seal number 9.
For respondent. This is wife petition, my lord, challenging the interim maintenance. Your last main matter is posted on 7th for judgment, my lord, final judgment. Kindly have it on yet, my lord.
Why should it be? Why should it be? What is the nexus between the two? That's a final order.
Yes.
This is an interim order. We'll decide it. No adjournments. Yes. 9.
This
Please come to
petition-
the interim order.
No, this petition is not served for consideration.
But then we'll dismiss it.
Yes, for that aspect, my lord, only for yet, kindly have it on yet, my lord. What the judgments will be trial court will withdraw for this. Only on that aspect, my lord.
This is matter on
Please,
11th of November.
Please.
Whatever is, whether it is pronounced, not pronounced,
Please.
we'll pass orders independently
Please,
on this. No further adjournment will be granted.
please, please.
Yes.
Seal number 10. J. Shetty. J. Shetty, serial number 10.
No representation on behalf of, no representation for the petitioner. This is matter for dismissal tomorrow. Yes, next.
Seal number 11.
On behalf of the, I seek a week's adjournment.
Why?
We take fresh adjournment, fresh notice. We ask the party to furnish a new address. By next week, we'll furnish it.
What is this impugned order?
I number 3 was filed by the JDS saying that they have already paid the excess amount to DHR. But we have also filed a memo of calculation. But hearing on the both the sides, the trial court has come to the conclusion that JDR has already paid excess amount. The same has been challenged. Our ground is only that they have to pay the interest with the solution. That has not been calculated in the trial.
Who are the respondents?
Executive member and SLO are the respondents.
Where is impugned order page number?
Page number 17.
Hmm. Seventeen. That is the interim application under section so and so is allowed.
That was the, sorry, ma'am.
Where is the
The
present
appeal
one?
order is at page number 51, ma'am.
51.
I number 3 under or 47 2.
51.
51. Order on I number 3.
Hmm. You are the JDR,
No, I was for the DHR.
THR.
DHR.
JDR has paid an amount of rupees 5,02,070 excess to the decree holder.
Yes.
The said excess amount is meager one. A decree holder being land user, hence if the said excess amount is with decree holder, no hardship will cause.
But
So
the-
how are you agreed by this?
No, they have not calculated the interest as per section 28 of the Land Acquisition Act. That was our ground. We had also filed a memo of calculation, but our memo of calculation has not been considered.
Where is the decree? First come prepared, we'll see, we'll think about the notices later.
Tomorrow we have to.
Yes, yes, day after tomorrow, at the request of concurrence for the petitioner. Yes.
There are different steps in respect of respondent number 1, then
Huh?
needful is done.
Needful is done. What is this, what is the impugn order?
No, impugn order is at page number 22.
What is the maintenance granted?
Maintenance is granted in the law by the trial court in the law. 3,000 and to the right and 2,000 to the daughter.
5,000. What is your?
8,000. Earlier it is 5,000.
Oh.
It is increased and 8,000 is granted. My submission is that for this under the court, without jurisdiction, trial court has granted enhance the maintenance fee. Because she is not a resident of Koppal district, and he is earlier he files maintenance petition for Gadar district court, and against that before this under the court appeal is preferred, and I prefer diverse petition, in that diverse petition, she is residing in Koppal, now, as per the instruction of my client, she is residing at Kalburgi, along with her daughter. Her daughter is admitted in the school of Kalburgi. So my submission is, without jurisdiction, I have taken first contention that the trial court is not having any jurisdiction.
Which court passed this order?
Koppal district. She is not residing there.
Where are you residing?
I am residing in Delta, in Bhavipur district.
What is the finding? What is the finding of the court on that point?
Trial court has not considered any question of law in that point.
What is your? What is? No. What is your income?
I am as per the court, I am getting 22,000 salary per month. And I am having 2 children from my first wife, they are school going, college, they are college students, and I have mother also, old age mother. I produced an Aadhaar card also. In Aadhaar card, we say that she is resident of Dharwad.
No, when you obtain the divorce, no permanent alimony is granted to the wife.
No. Because there is order from this honorable court, in earlier appeals, 5,000 fees to both that I am paying regularly. Without paying, I am paying.
Then transfer the petitioner submits that the needful is done. This is matter after service of protest. Interim order earlier granted is extended till then.
There is no.
Huh?
There is
No interim order. Yes.
Full
When counsel submits the needful is done, this is matter after service of.
Respond number 23 has to be sufficient. Respond number 23 has to be sufficient.
In the notice to respondent number 3 returned as unclaimed, same amount, same service of notice. Yes. Yes, next.
Seal number 14, DB Patta. DB Patta.
No representation for dismissal tomorrow.
Seal number 15.
I may be permitted to deposit the arrears of rent before this honorable court marriage.
No, what are this office objections? It's
All
serial
are
number.
permitted.
Oh, it says about serial number 2 on counsel submission.
That's what my
Proof regarding deposit of rent of arrears to be furnished.
I may be permitted to deposit here before this honorable court marriage.
Why not before the same court? Generally, where you do deposit?
So even here in High Court also, my lords, even before the trial court.
Do it because it's easy for the parties. Yes, the petitioner shall comply with the office objection at serial number 2 and deposit the amount before the trial court.
Definitely.
Yes, next.
Seal number 60. Seal number 60.
2 days time to file.
Why you want 2 weeks?
Proxy counsel.
The PF shall be paid by 12th of November. If the steps are not taken, the petition shall stand dismissed without further reference to the court. Who has filed this petition? Why for the?
Copy has been served on the High Court advocate.
Just give that.
Seal number 17.
No, 16. Yes. Next.
Seal number 17.
17.1, I am filing a memo of dismissal as petition is withdrawn.
What about 17?
17.
No, it survives because
That's a
Memo. Take the memo. As far as 17.1 is concerned, a memo is filed stating that. That as a petitioner has received a possession of the suit land and is in possession and enjoyment of the property, the petition will be dismissed as not pressed. Accordingly, memo is taken on record. The petition is dismissed as not pressed. Yes, now let's see 17.
17.1, that survives. And for the petition respondent.
Not in this case, what has happened? The petitioner was the owner of the premises. The respondent number 1 hearing, 1 and 2 hearing were the tenants.
You appear for respondent number 1.
No, he appeared for proposed respondent number 3. That application is pending.
Then what about 1?
One, my lord, a notice has been issued, it has to be served. Awaited.
What is that? Insufficient address.
Petition premises address. Now they have vacated the premises. Now they are residing in some other village. That is called Majad. Hardly 15 kilometers from the present petition premise.
I will take fresh step.
The petitioner shall take steps in respect of respondent number 1. List this matter on, has to take steps by 13th or in same default order. Next. Set that mic properly, nobody is using it. Yes.
Matter is settled, my lord, it does not survive for consideration.
The council petition submitted the main entry itself is decided between the parties and nothing survives for consideration in this writ petition. Accordingly, dismissed as infructuous. Yes, next.
Seal number 19.
This objection is
regarding the legal copy of connection C but the relevant portion is legible.
Yes.
Lord's office objection is in respect of a legible copy has to be filed, Lords. That annexure C, Lords. But the relevant portion is legible, Lords.
Let's see where is it? Let's look at the
That's
office.
page number 22.
Legible copy of annexure C to be furnished. What is annexure C?
That is the order copy of the trial court, Lords.
Let's see where is it? Page number?
22, Lords.
How do you say that it is legible? File a typed copy for this. Why should we break our head to read it? The office objection with regard to the filing of a legible copy is sustained. Petitioner shall file a legible typed copy. Yes.
Yes.
Yes, next. Shall file the copy by 14th of November. Let's this matter on 19th. Yes. Some default order. If it is not filed, the petition stands dismissed. Is next. No representation for dismissal tomorrow. Same order.
I seek for a week's time to file this affidavit.
The land council submits that is already taken steps for issuance of notice to respondent and for filing affidavit. It seeks a week's time. Same, a week's time default order. Yes, next.
Please.
Next.
Madam,
Yes.
petitioner. Filing this petition because I have to transfer the case from Hubli trial court to Bangalore trial court. On the grounds of that, my client is working there with the child also studying there. And because of 2 working days, we need to travel from there to there to attend the court.
Who filed the MC here?
Pardon?
Who filed the MC here?
And I'm only at the time of the thing is that at the time of coming back to India from the US, we will be residing here in Hubli only. But to take out the day-to-day livelihood and the children's education, I shifted back.
Where the husband is staying?
In America, in US.
Oh, you're in yours.
Yes, sir. I
The
am in
respondent-
USA, my lord. Matter arises in this way, my lord.
No. Issue is like this. Now, where the cause of action and all that we are not going into. You are residing in yours. She is working in Bangalore. Now, if this matter is transferred to Bangalore, it doesn't make any difference to you.
Please, ma'am, I am also saying that 1 decade has been already spent. This is not matrimonial case. It is original suit 10/2014, my lord, filed by the wife before the family court at Hubli on the ground that the husband has obtained a decree of divorce by Alabama court, USA. And that has been called in question on the ground that we declared that it is not binding on her and null and void, my lord. But
It is already.
but the point is that, my lord, after lapse of nearly.
So that we will not be deciding here.
Yes, ma'am.
We will not be deciding. It's only a transfer petition.
Yes, ma'am. Convenience of a party is also to be taken into consideration.
Where are you? You're in yours.
Since my client is residing at USA, he is working there, he is permanently put up there. Whereas this lady has obtained MS degree, thereafter she came to India on
That is all due to because of.
Let him say.
on 6/2/2013. Since then, she has resulted and residing away from him. She got a job at Bangalore. And earlier, since from the beginning itself, since from filing of this particular suit, OS number 10/2014, she is residing at Bangalore itself. To that effect, I have produced a document stating that she is permanently residing at Bangalore. I have produced her the annexure Archen, my lord. Aurora, in that annexure, in that
how she is residing since from beginning itself, my lord. No, after lapse of 10 years, the evidence of the petitioner is completed.
No, what is the stage now?
No, the
Evidence
stage
is
is.
not completed.
Trial commenced?
Yes, trial commenced, my lord.
Madam, but last there is for the settlement from the last 1 year. The
Oh,
thing is that.
just wait. What is that you're seeking? What is that OS number?
Where's number 10 bar 2014, my lord.
No, you filed a transfer petition in 24.
Yeah, because the thing is that every time there will be like lapse of, they are going for the settlement and not doing the.
Please come to your affidavit. What did you say in support of your affidavit?
And
Come to Annex D. Page number.
There are so many cases which are.
Now the trial has commenced. We will not transfer this. Please come.
but it's not, it is been trial has commenced because the process for evidence, it has not yet on the board.
Then you please, please come to page number 27. What is it on the proceedings?
27.
Call for further chief of PW2, PW1. That's on 17/2/2024.
In the meantime, it has been gone for settlement.
Whatever it is. A 2014 suit cannot be transferred in 2024. Yes.
No, no, I think that actually it is getting more and more problems for the client. Because
Maybe,
two working
maybe.
days.
The court has spent enough time on your case. No, it can't be. At this stage, it can't be transferred.
No, it is really very much. And if it is so transferred to.
Issues are framed. Why should we? What were you doing? When did you get the job in Bangalore? Please tell the court. What did you say in that regard? When did you get the job? When you filed a petition on the jurisdiction issue, you have contested it.
Yes,
So let's see what was. Please come to the facts. And what are the reasons that are stated for transfer of this petition? No, you say like your son and you're working. Your son is studying and you're working. So when you started working, that's a factor. He says that you have been there right from the day you have instituted the suit. You are residing in Bangalore.
No, I will take, can you give me a week of time?
Yes, I will post this matter on 13th of November. By that time.
It is on for evidence on 27th of this month. Okay, anyhow.
It doesn't matter.
Okay.
Please get instructions on when did she, from how long she has been residing in Bangalore.
Sure.
That we will see.
Thank you.
This is matter on 13th by the time.
27,
Huh?
13th, I mean,
13th.
13th, instead of 13th,
Why should it be 27th? If not 13th, then you have 19th also. This is on 19th. Yeah. By the time then transfer the petition shall place before this court, the shall get specific instructions from when the wife is staying in Bangalore. Yes.
The wife's petition was seeking transfer from Belarus to state. That's the husband.
What's the distance?
That's
What is the distance?
52 kilometers. As on the date of filing of this petition, the wife was 8 months pregnant. Recently, she has delivered a baby. Even though the husband is a resident of Ukeli, he has purposely filed it at Belarus. The cost title in this petition.
थोड़ा ये change करो direction थोड़ा इसमें आ रहा है
Even though he is the resident of the same taluk,
wherein the petitioner is residing. He has purposely filed it in Belgavi.
What's the stage? Which year is this MC?
2024 numbers.
Please come. The present petition is filed seeking transfer of MC number 190 of 2024, pending on the file of the first resident principal judge, Family Court, Belgavi, and to transfer the same to the principal senior civil judge to carry. The facts of the case are: the marriage has taken place on 7/8/2022 at Banshankari Temple, Belgavi. The disputes arose between the parties, and it's a case of the wife that she was thrown out of the matrimonial home on 14/12/2022. Thereafter, the husband had filed MC number 180 of 2024 before the first additional principal judge, Family Court, Belgavi, seeking divorce. The wife is residing at Delhi and working as a primary school teacher at Ammanagi village. By the time she was thrown out of the matrimonial home, she was 8 months pregnant.
No. As on the date of filing of this petition, she was.
When the husband has filed the MC, by the time she is 8 months old pregnant, and as it is difficult for her to travel, both on the grounds, on medical grounds, as well as the fact that she is working as a teacher, the present application came to be filed. The land counsel appearing for the petitioner, the land counsel appearing for the petitioner submits that considering the fact that now she has delivered and she is having a small baby to be taken care of, it would be very difficult for her to travel from so and so to so and so. In view of the same, the MC pending before the court at so and so may be transferred in the interest of justice, and particularly considering the difficulties of the wife. The next para, notice to the respondent is returned as refused and submits to deemed service of notice. Next para, having got the land counsel for the petitioner, Faroes entire material on record, considering the fact that she has the boy. She is, as on the date of filing of the petition, she was 8 months pregnant. Now, as per the submission of the land counsel, recently she delivered the baby, and it would be difficult for her to travel on each date of hearing. This court deems it appropriate to withdraw MC number 180 of 2024, pending on a file of the first edition of Principal Judge, Family Court, Belgavi, and transfer the same to Principal Senior Civil Judge, Ukeri. Accordingly, petition is allowed. This next.
Still number 25?
Yes.
Seeking from Lakshmi to highway, distance is around 55 kilometers, and the petitioner wife has filed a criminal misdemeanor. The respondent husband is remaining absent and issued the FLW. Thereafter, he immediately filed the application under section 30 for divorce before the Lakshmi court. Hence, she is residing.
No, first wife had filed criminal miscellaneous seeking a maintenance at which place?
That having that can be allowed. Thereafter, she filed under section 26(1) and 2 and under Domestic Violence Act for recovery of the evidence. The respondent did not appear before the court and issued the FLW. Thereafter, intentionally he filed before the National Court for divorce.
Please come. Present petition is filed seeking transfer of so and so. Seeking transfer of MC number 52 of 2024, pending it before the senior civil judge and JMSC Lakshmeswar to family court, Haveli. It is the facts of the case are the marriage has taken place on 31/3/2016 at Nave Bavanur village of Shirahatti Taluk, Gadag district. Due to the harassment, it is a case of the Vaita. Due to the harassment meted out by the family of the respondent, she has moved out of the matrimonial home and later she filed criminal miscellaneous number 132 of 2018 before the civil judge and JMSC Haveli for maintenance, and the same is allowed. The court had directed the respondent to pay the maintenance amount of rupees 3,000 per month. Later, the wife had filed an application under section 26(1) for the Protection of Women from Domestic Violence Act before the Principal Civil Court, Haveli. As the respondent had failed to appear, the court had issued FLW to the respondent. After this, the husband had filed an application seeking divorce before the senior civil judge and JMSC Gadag. It is stated that that there is threat to her life, and it's very difficult for her to attend the courts at the respondent's place. The father and mother are poor. The distance between Lakshmeswar to Haveli is more than 50 kilometers. Further, the petitioner is also having health issues and she is not able to board the bus alone. Hence, the sort for the transfer. Next para. When counsel appearing for the petitioner submits that already a criminal miscellaneous is filed which is allowed, and even the domestic violence case already the court has already issued FLW. He submits that as a case is pending here, and considering the health and the financial reasons of the wife, this court may transfer the MC 52 of 2024, or else the wife will be put to irreparable loss and hardship. Next part. Notice is as per the cost list. The notice to respondent returned as refused. Amounts to deemed service of notice. Next, having heard the land counsel for the petitioner, there is the material non-record. The wife had already instituted the cases at Haveli, and already maintenance is granted, and in the domestic violence case, the court has already issued FLW, considering the fact that that already a matter is pending before the court. This court deems it appropriate to withdraw MC number 52 of 2024 pending before the senior civil judge and JMFC Lakshmeswar to family court Haveli. Accordingly, petition is allowed. Yes, next.
Office of Petitions, my lords, the father has burned the affidavit and Wakala case. Since the lords, the petitioner, the lords, is in judicial custody from 25/7/2022. He may kindly be explained to the lords, represent his son.
No, but somebody he should use the GPA or something.
No, he is in judicial custody. Because the laws, section 125, the clause 3, the law says 1 month the law says imprisonment. The law says or if the sooner than it is named. The law for 25/7/2024, when till this case, the law is in judicial custody. The court is extending this judicial custody, the law is for non-payment of arrears of maintenance. My lords, he is released from the judicial custody, my lords.
No, no, what's the difficulty if he is in judicial demand also? What is the difficulty in signing the papers?
My lords, I can't swear the affidavit before the notary, my lords. And I have to swear the annexures also.
Where is that? What is the procedure? Let's see.
My lords, we have to file an affidavit. My lords, annexure should be sworn before the notary.
Where do you get that?
In the High Court rules, my lords.
Oh, no, no. From these papers I'm looking at it. Which are filed there? What is that you have filed there?
That's affidavit. States are stated.
So every affidavit shall be before the notary.
Yes, my lords. In a criminal case, my lords, the memorandum of facts of the advocates will be accepted by the criminal court when the person is in judicial custody. This is the case of noting writ jurisdiction. The father of the court, the petitioner, has signed the wakalat as he is in judicial custody. Next, we must the Aadhaar card of the father.
No, no, there should be some procedure. I don't think that there is no other way but the father has to file the affidavit.
No, except this not the petitioner has no other way because he can't come out and.
No, he can't come out. He can say that the father will represent him, or he can file a case on his behalf. Some chip is you can authorize the father to do all that. No. Why?
GPA can't be executed in the jail.
No, there must be some procedure for all the legal proceedings. The next friend or something, there would be some procedure for that. Now, even when bails are filed, when they are in the jail, that being an next friend or something, that's how they are filed. Or there is a procedure for that. It is not that you are completely remedialist. Follow that. The office objections are sustained. Petition shall come up with an appropriate application.
Well, file an application seeking the lord's permission to proceed.
Yes, whatever you want to do, list this matter on 11th November. Yes, please.
Anyone else? Number 28?
Say council, madam, seeking 2 days accommodation.
Any interim order?
Yeah, there is an interim order, but they have filed an IA. It is in Kannada language, asking them to file it in translated language.
At the request of land council for the petitioner, this is matter on 12th. By the time the translated copy of the IA shall be placed before the court. Yes, next.
Yes. There on the petitioner. For the revision petition, there is a delay of 32 days. The present petitioners are the judgment debtors, and the respondent here is the decree holder. So the respondent here has filed a suit for declaration and injunction seeking easementary right. After contest of the suit came to be decreed, explaining the defendants not to interfere with the A, B, C, D road is concerned. Thereafter, my lord, in order to execute the decree, he files an execution petition under order 21 rule 11 to execute that order. There, my lord, the trial court passes an order sending the present petitioners for civil imprisonment for a period of 3 months in view of violation of the decree. My lord, my respectful submission to the lordship is that the provision under order 21 rule 11 is pertains to only where there is disobedience with regarding to money decrees concerned. Here it is only a suit for declaration and seeking injunction against.
So then when a decree is violated,
yes,
any injunction that is granted is violated.
Then they have to file a miscellaneous under seeking disobedience with regard to under order 39 rule 2A. That aspect has
So
not been
that
followed.
is, that's about a quoting of a provision of law.
Yes.
Otherwise, what is the procedure that's
No,
going to change?
the procedure itself is that they have to file a miscellaneous, but the executing court cannot pass an order. That is wherein the provision itself, under order 21 rule 11, the
Let's see
order
the
is
order.
passed. My lord, may I take it lordship as page 34?
34.
May I read?
Please read.
Please, the present execution petition has been filed by the decree holder under order 21 rule 11 CPC. The brief elements of the execution petition are the DHF filed a suit in OS 82 against ADR 1 to 5 who are defendants 1, 5 to 8 in the above said OS for the relief of declaration and permanent injunction. The suit property with Gram Panchayat number 5A, the old Gram Panchayat is number 2 with boundaries towards east house of Ruga, towards west properties belonging to areas and others, towards north properties of Jesnu and Unkal, and towards south vacant land owned by the areas of Hirenarchi village in Volta. The plaintiff is the absolute owner in possession of the property towards the southern side of the district way. The original defendants got their vacant land with Gram Panchayat number 3 towards east, north, south 6 feet way, of which the DHF plaintiff is in physical
Why
enjoyment.
you are not appeared before the court?
Please.
Why you are not appeared before the court?
My lord, since my respect is sufficient insofar as appearance is concerned, since they are the villagers where they could not go and approach. However, my lord, notices were served to the judgment debtors, but they could not go and approach.
How can you come to this court?
Allah, only when an arrest warrant was issued by the executive and they were taken to the custody.
First of all, when you have not appeared before the court,
yes,
and you have not contested the matter.
Yes, but since my lord, the court could.
No, being a rustic villagers, they don't understand that under which provision of law application has to be filed.
Yes.
But they can understand that once a notice is received from the court,
they
should appear. So, what is the purpose of passing these decrees
Lord,
on the ground of these technicalities that it is not maintainable under this, it should be under some other law. But the fact remains is you have violated the decree.
My lord, violated the decree is that the court should have, before passing the order with regarding to the civil imprisonment, an inquiry should be held whether.
But you are not there. You didn't come to the court. What the court can do? Court has given you an opportunity.
An opportunity was given.
Then you didn't come. What the court should do? Then when you don't have respect to the court, the orders, why should this court come to your rescue?
At least they would have.
Let's not go on the procedural aspect.
Even though inquiry is not, my lord, the court would have passed for with regard to attachment of property. That is also not the state away. They have been taken into custody in view of notice having been served, and they have been.
First of all, you violate the decree. Then you don't appear before the court. Then you come before the appellate court saying that a revisional court that this is some procedural irregularity. There should be some sanctity to the order of the court.
That has to be accepted by the parties while appearing before the court also. But my
that is not done, first of all.
That is not. That is on record. It shows that the petitioners have not approached the executing court in time. Only at the time the arrest warrant.
Then once it's an ex parte order.
No. Suit is declared on contest.
Not the suit.
Executing it is an past ex parte order.
Ex parte order. Then when once an ex parte order is passed, you have a remedy. You have a remedy.
My lord, this remedy is, my lord,
to come by the revision. No. For the very same court, you will have a remedy.
No, my lord, but an effort was made.
Effort where and how?
But there is no order, as our application itself has not been accepted by the court.
So, if that is not, that's pending, then your remedy is to come before the court,
yes, saying
that let the court hear my application, but not filing a revision before this court. So, at every stage, your client is bypassing all the remedies and not doing what he is supposed to.
Already they have been taken into custody and they are in custody for last 15 days. They are in custody.
What is to be done now?
Or at least the court would have taken seriously and stringent conditions would have been imposed on the petitioners at the time of passing any.
So why should that lenience be shown now when you don't have respect to the orders of the court? What will happen if these kind of cases, if the court starts interfering, then why any litigant will obey the orders of the court?
At least, my lord, the court would have
No,
Strictly, first of all, they would have.
That's the first step. That's the first step is, you should have been, first of all, you should have done something which you are supposed to do. And you should have gone to the court and said that, informed the court that, you cannot pass such an order or whatever it is. You don't contest the matter. Order is passed. Now you are in the civil prison. So, and apart from that, you have a remedy of filing a petition which you have already exhausted. That application is pending.
That application itself is not accepted by the court.
Why not accept? It's not.
Even
Why they have refused it?
Even note is also not that I will not accept any application if you want to get order from the higher courts. That is the oral submission.
It can't be, no, that you will file it in the section. Any application, won't you file it in the section?
Oh no, in the open court. Advancement was made in the executive court when they were arrested and the application was submitted, but the court did not accept it. Since already there is an order that the petition shall be taken into custody. But there is no forthcoming with regard to that we have made an application that has been accepted and that has been refused. That is not forthcoming in the order sheet which has been maintained. Over my lord, all the petitioners are senior citizens. They would have obeyed the order.
They should have realized it before.
Now they have realized what is the fate if not obeyed the court orders, my lord. But now for the last 15-20 days they are in custody. So my humble request to the lordship is that, my lord, and then this let the petitioner shall be and yet.
How much is what is as per the order? What is that? Let's see.
Please. Decree, my lord.
No. This what is the imprisonment?
Imprisonment 3 months, man. Civil imprisonment for a period of 3 months for disobedience at page 38.
Take out notice. Already there is a delay.
Yes.
Notice in I number 1 of 2024. Petition is permitted to take out notice on the council appearing for the respondent before the trial court and shall file a memo to that effect.
Please.
Let's just matter on 14th of November.
Please.
Yes. This petition is filed in the year 2023 and till 22/2022 on 22/2024 the order shows that a 2 weeks time is granted to do the needful. Then the matter came up on 21/10/2024. There was no representation on behalf of the petitioner and this court had directed the matter to be listed under the caption for dismissal on 22/10/2024. On 22/10/2024, again there is no representation, hence directed the matter to be listed today under the caption for dismissal. Today also there is no representation. It appears that the petitioner is not interested to pursue the matter. Accordingly, dismissed for non-prosecution. Yes.
To go to the short accommodation, my lords. Senior is not there in the town. I seek a short accommodation. The matter pertains to rejection of claim, wherein the application filed by the present petitioner was rejected by the Honorable Court on the ground that the Bombay Wards Act is not applicable, and subsequently the judicata is also not applicable. In detailed hearing will be done by my
No such a detailed hearing not required for this. I can understand from the facts you are saying. When is your senior available?
After 2 days.
Yes, this is matter on 6th of 6th. Yes. Yes.
Great, my lords.
Petitioner, week's accommodation, to furnish the acknowledgement for having served the copy,
What has happened from 2022? On 3/2024, at the request of counsel, the petitioner listed up to 2 weeks. In 19/2/2024, same request. Already against respondent number 3, division petition is dismissed.
Petitioner never has directed to file a copy of the petition papers before the executing court. Send the paper to the company lawyer, to send it to the.
Let's see what's the included order. Then we will think about whether notice is important.
Please.
Yes. Where is the included order?
Page number 20.
Page number?
Page number 28.
28.
The relevant portion of the order, Malad. It starts from Malad, page number 24. In the execution petition, Malad, a memo of calculation was filed by the decree holders for payment of the balance amount, Malad, it was awarded in the ministry.
No, which page number you're saying? 24.
24, the order starts, Malad.
There's nothing in 24.
34, deep page 34. The memo of calculation was filed by the decree holders. The same was objected by the insurance company. On the ground that the amount which was paid on 36,000 was the only amount which was payable by the company. That has been paid. But there was no due amount that payable by the insurance company in order to satisfy the decree. The executive court rejected. The executive court rejected the objection raised by the insurance company and has passed an order to direct rupees 2,18,000 on the basis of the memo of calculation filed by the decree holders. That order is under challenge for this honorable court.
So court has directed to pay rupees 2,18,055.
Yes.
So how it is wrong according to you? We see the calculation at page number 36.
As per the objection raised, my lord, the calculation submitted by the petitioner insurance company, my lord. As in the date of filing of the execution petition, the amount payable was only 36,000. To that extent, the memo of calculation was filed, my lord, that amount was deposited immediately after filing of.
No, please come to it. What is wrong? Now, basing on this calculation, court has passed an order. So please look at at what step it is wrong.
What executing court has done, my lord. Whatever the amount deposited by the insurance company in compliance of section 30, and even after the receipt of the amount by this honorable court to be concerned, the tribunal has deducted that amount towards the interest portion.
No, that's how. No, first of all, on the court has relied on a judgment also.
And then again, my lord, calculated the interest.
No, then give your calculation memo. Let's see. Give your calculation memo. Now the first towards interest, cost, and the original amount. From the date that is from, what is the date? Your interest has to be calculated from 4/10/2017.
From the dismissal of the appeal.
So from 4/10/2017 till you realize pay the amount, on that amount, first.
The amount which was deposited before this honorable court at the time of filing the appeal, my lord, that amount has been transferred along with the interest.
No, what we have to see is, by the date you paid the amount, what is the interest that accrued, how much is the interest, whether you have paid it or not, then the cost, then the principal. That's how the calculation. Please get the calculation memo and please tell the court how is your calculation memo, where is this difference, that you please highlight. Then counsel for the petitioner shall file before this court the calculation memo. List this matter on 20th of November.
Yes.
Yes. Next. Which one? 30? 36. I think this also they've asked. This also for adjournment.
33, 34, 35.
Oh, not 36.
Number 36.
Yes.
Hearing for
Yes. What is this?
Send for maintenance was dismissed.
How much is the maintenance granted?
It's dismissed.
Dismissed against the wife. I mean,
Dismissed, filed by the wife also.
no representation for the petitioner. List is part of a dismissal. Counsel for the respondent is present. Yes, next.
Number 37.
The respondent has filed the suit for notice and separate petition and alternatively reopening the petition OS number 5 society was compromised before the Lok Adalat. After filing that appear and WS has filed by the petitioner and contested the matter. Thereafter, during the pendency of this case, whereas the application was filed, area number 6, rejection of claim. The trial court has said application was rejected only on the ground that cannot have a portion of this case. The alternative prayer is the reopening of the compromised petition was alternative prayer. It is not a main prayer. But contents of the plate awareness very much clearly disclose that entire partition was taken earlier. They have taken the contents in kindly.
First, please come to your IA
Please.
under Order 6 Rule 17.
Please.
Order 7 Rule 11.
Yes.
Yes. Where is that?
Page 34.
34.
Let's read the affidavit.
Second term, that the plaintiff shall file the present false suit for the uniform possession and alternatively for reopening of the partition in respect of the suit schedule A property against the defendant only to grant his properties without there being any right, title, interest and possession over the suit property and without creating any cause of action as earlier. The present defendant has filed this suit OS number 233/2005 on 29/9/2005 before this honorable court. And during the course of trials, the said suit was ended in compromise with the intervention of the village elders, and according to the plaintiff and defendants have filed a joint compromise petition dated 21/1/2006 before this honorable court, along with the joint memo submitted by both the parties, praying to the court that the said suit may refer to Lok Adalat, and the honorable court has referred to the case of Lok Adalat, and both the parties of the OS number 233/2005 have agreed the terms and conditions of the compromise petition as which are lawful, and with the consent of the both the parties, the said suit is compromised and passed the final decree as per the terms and conditions of the compromise petition. And accordingly, the final decree was drawn on 5/7/2006. Accordingly, as per the said compromise decree, the parties of the suit OS number 233/2005 are put in possession of their respective allotted sales, and they have got entered their names in RFR of their respective allotted lands by creating the MR by the Revenue Authority. Accordingly, as per the said compromise decree, in OS number 233/2005, the very defendant is having absolute right, title, and possession over the suit schedule A properties, and the very plaintiffs are defendant number 5 and 6 in OS number in the presence of the present plaintiff. The said compromise petition was filed with their consent and their presence. The said compromise decree was drawn as they are the signatories of the said compromise petition. This being the facts, after lapse of 12 years, the very plaintiffs have challenged the said compromise decree by filing this present suit dated 16/6/2017.
Please come to the plane. Where is the plane? Page number?
Page number, yes. In page number 14.
Yes.
Okay, page number 15, madam, the agriculture lands are stated in the schedules of the first para, madam. The agriculture lands bearing number RS number 147/3 and 147.
Don't have to read. Come to para number, please.
Para number 5, madam.
No, let's understand the relation.
Relation between the journals stated in para number 2, madam, is propositus Bhima. The present Siddhappa, second son is Siddhappa is the present petitioner, and present in this case respondents are Kundli and his son, second respondent. Present petitioner is Siddhappa, and here in respondents are the Kundli and his son. And
Please read para number
3. The defendant Siddhappa had filed OS number 233/2005 on the file of this suit, this court against the plaintiff and other Bahubandas in respect of lands bearing number RS number 147/1, 147/2, 147/3, 147/4, measuring 4 acres 31 guntas, 2 acres 15 guntas, and 5 acres 29 guntas, and 2 acres 14 guntas, respectively situated at Dharwad village. The same came to be compromised, and the very plaintiffs defendant number 1 and other parties in OS number 233/2005 submitted compromise petition on 21/1/2006 under our 23 Rule 3 of CPC. The very defendant filed suit OS number 233/2005 for partition and separate possession. On the file of this suit court, the parties to that suit have got settled their dispute on 21/1/2006, and accordingly equal share out of suit property is allotted to the plaintiff and defendant number 2 to 6. In that suit, the very compromise petition submitted by the para 2 reads as under in Kannada version. ಪ್ರತಿವಾದಿ ನಂಬರ್ 1 ಇಟ್ಟಪ್ಪ ಅಪ್ಪಾಜಿ ಕಾಲ್ತಿಕ್ಕಿ ಹಾಗೂ ಪ್ರತಿವಾದಿ ನಂಬರ್ 2 ಮುರಾರಿ ಅಪ್ಪಾಜಿ ಕಾಲ್ತಿಕ್ಕಿ ಮತ್ತು ಪ್ರತಿವಾದಿ ನಂಬರ್ 8 ವೀರಪ್ಪ ರೇವಪ್ಪ ಕಾಲ್ತಿಕ್ಕಿ ಇವರಿಗೆ ಒಟ್ಟು ದಾವಾ ಜಮೀನು 15 ಎಕರೆ 9 ಗುಂಟೆ. ಇದರಲ್ಲಿ ಅರ್ಧ ಪಾಲು ಇದ್ದು ಅದರ ಪ್ರಕಾರ ದಾವಾ ಆಸ್ತಿಯ ಅರ್ಧ ಜಮೀನು ಕಬ್ಜಾ ಇದ್ದು ಉಳಿದ ಅರ್ಧ ದಾವಾ ಜಮೀನು ವಾದಿ ಮತ್ತು ಪ್ರತಿವಾದಿ ನಂಬರ್ 2 ರಿಂದ 6 ಇವರ ಪಾಲಿಗೆ ಬಂದಿದ್ದವರು ಕಬ್ಜಾ ವಹಿವಾಟಿನಲ್ಲಿ ಇರುವರು. ಕಂಟಿನ್ಯೂ ಪ್ಯಾರಾ By reviewing the para 2 of the compromise petition, it is crystal clear that the plaintiff has.
Please come to the prayer straight away.
Please. Prayer. Amen. A decree for possessing the first awarding land RS number 147 per 12 and RS number.
So, before you read this, there is no dispute about the fact that these plaintiffs and defendants are the plaintiff and defendants in a compromise.
Yes.
Same parties.
Yes.
So,
Both situated at Dharwad village from the defendant. Alternatively, half share in the suit scheduled properties to be awarded to the plaintiff from the defendant. And prayer B manifest. Alternatively, the partition obtained in OS number 233 for 2005 by practicing fraud on the plaintiff dated 21/1/2006.
so by filing a separate suit, they want the earlier partition decree that is passed has to be revisited in this.
We are seeking reopening that earlier.
So let's come to the order.
Page number.
Where is the impugned order?
Start from page number 7, madam. The operative portion is stated in the para number 13, page number 11. It is 30 from 13.
Para 12 you can take.
12.
It is bird's eye view of the rival contentions.
Para 12.
12 at page number 11.
With these bird's eye view of the rival contention put forwarded by the competing parties, let me disappear the meetings and view the same in the regard of light of settled principles of law. It is the specific case of the plaintiff that dispute between the plaintiff and defendant is compromised in OS number 233 for 2005, and the parties have filed compromise petition on 21/1/2006. It is further submitted that, having regard to the paragraph number 2 of the compromise petition, that plaintiffs and defendant number 2 to 6 in that suit have got half share in the suit property. But in paragraph number C and D of the compromise petition, the defendant have played fraud and narrated the different shares which is opposite to the paragraph number 2 of the compromise petition. Apart from this, the plaintiff
No,
has,
basing on what he is seeking recovery of possession.
yes, sir, he has what is granted as per the compromise, sir, he is possession as per the compromise.
No. This relief of just now the place we have read, what he says.
With kind permission. But initially, my lord, the suit scheduled property belongs to.
No, before that, just as far as this prayer A is concerned, what is it?
Prayer A, according to the previous compromise petition law, half share was granted to our branch, means including plaintiff and defendant, and other half share was given to my uncle's branch. In the compromise petition, the first para, specifically it was mentioned that half portion, total 15 acres was the extent of the land. Out of 15 acres, 7 acres was granted to my family and other 7 acres was to my uncle's family. That was the crux of the compromise petition. But in the subsequent paras of the compromise petition, not even a single gunta of land is allotted to the plaintiff. On the other hand, these shares which have been allotted, in fact, as per the compromise also got, the plaintiffs and the defendants, they are entitled for half share, 1/8 share in the suit scheduled property. In spite of that, no property was allotted to the plaintiff. Now, my lord, by virtue of the compromise, admittedly, according to the defendants, I have a share in the compromise petition.
So, this prayer number A,
yes,
you are seeking execution of the compromise decree.
No. The share was allotted to all 4 brothers, including the plaintiff, defendant, and others. But in the compromise petition, no share was shown in respect of the plaintiff. So we are seeking the partition in respect of half which has been allotted in the previous compromise.
That's
what. We are not
You
seeking
are
a fresh compromise.
No. It is not a fresh. Whatever it is, you are a kind of clarification you are seeking of the decree. For that, a separate suit be profiled?
Yes, Lord.
How can it be?
No.
I'm not seeking, my lord, I'm only agitating my right by virtue of this compromise.
Correct.
Yes.
No, a compromise decree is passed. After 17 years from the date of a compromise
The
decree,
reasons for now approaching the.
even for that also,
Yes.
how can you file a separate suit for that?
No, since my lord, on the last occasion, my lord, the compromise petition was directed to be produced before this honorable. May I request, my lord, the compromise?
No, let us accept that.
Yes.
Whatever your prayer at A is concerned,
Yes.
as per the compromise decree, so and so is awarded to you.
No, I have not been allotted any share.
Though, according to you, it should have been part of that.
Yes.
Even for that also, how can you maintain a separate suit?
As per the recent judgment of this honorable court, my lord, I cannot file a either law on the point, my lord, was that the compromise petition has to be challenged before this honorable court under 226.
No, it's fine. Is this an award passed by the Lok Adalat or by the court? Lok Adalat.
Yes.
Then, if there is anything wrong, you need a clarification, and petition has to be filed before this court.
Now, my lord, the recent judgment of this honorable court is that, my lord, I have to file a separate application recalling the compromise decree entered before the Lok Adalat, or I can file
before the very same court.
Same. So now, my lord, this suit is filed, my lord, in the year 2017. The respondents, the defendants appeared.
No, even as on that day, whatever is the law that was holding the field, still, how can you maintain a separate suit for this?
Admittedly, no share has been allotted to the claim.
Then what you are supposed to do? Whatever that has to be done by you at that point of time, you can't keep quiet till 17 years.
No, the reason, the cause of action para also, my lord, in the claim, my lord, I have specifically stated that since I was out of the village for my livelihood, I was under the impression that my brother is holding.
No, if this is the manner in which it has to go, then there is no end to the litigation.
No, my lord. Admittedly, my lord, in the compromise petition, as per the second para of the compromise petition, it is specifically mentioned that my family has a half share in the suit.
So, as on the day when the compromise decree is drawn, you are aware of the fact that whatever that has been stated is not reflected in the
compromise.
If that's the case,
yes.
How can you file a separate suit for that? It's in the very same. Nothing. There is no question of fraud also, because you are a party to the compromise.
But the thing is that, my lord, in the compromise petition, which is placed before this honorable court, my lord, the other three brothers, my lord, they have.
I can understand if you have said so that the compromise has been obtained by playing fraud, and that is not binding on you. That's a different aspect. Look at your prayers.
Now, yes, I'll just.
Again, please come to your prayers and read.
Yes. My lord, in the prayer at, my lord, in page 18.
Yes.
My first prayer is, my lord, decree of possession.
So, this decree of possession would be unless and until that the judgment and decree or a compromise decree is altered, you can't have this prayer number A.
So, next prayer, my lord.
Yes.
Next prayer is alternatively partition obtained in by practicing.
This can't be an alternative prayer. This can't be an alternative prayer. No. This is your main prayer. You are seeking by virtue of this.
But in the cross-examination, now the matter is posted for argument.
No, like however, by nicely terming and using and framing the prayers, you can't change the. Ultimately, meaning remains to be the same.
No, that's similar. But my prayer is, even the defendant, in cross-examination, he admits that I have a share in the property. He has admitted in the present.
Even if both of you admit everything, yes. But still, whatever that you are entitled legally to proceed as per the procedure, that only you will be entitled. Now, because both of you are agreeing, something can't be done. This prayer, as it is, you can't maintain a suit at all.
No, in view of recent judgment, I'll place it on record.
No, I know the judgment.
Yeah. Their Lordship Justice Sandesh have passed a judgment wherein the categorical finding is given saying that I can maintain an application for recalling the.
No, it's not. It is a judgment of the Supreme Court. That's a basing on a judgment of the Supreme Court that's passed.
Yes.
It is made very clear that you cannot file a separate suit.
Not may grant me some time, not I'll examine it.
And on the face of it, you can't maintain a
Not may
suit.
friend peruse the compromise deed where it is not given my court.
No, I'm saying that I'll accept, without even looking at the compromise, some injustice is done to you.
Yes, yes, definitely.
Let's accept.
Yes.
In spite of that, you can't maintain a suit like this. Your remedy is
No,
not to file a
only
suit.
remedy would be not, otherwise not, I have to seek for restoration of the compromise.
Under these, then the court has a reason to look at it and what does the injustice cost you? Court will appreciate that.
I'm not
Get instructions and list this matter as partnered on 12th November on the top of the list.
Please.
Yes, next. Exactly. No representation for dismissal tomorrow on behalf of both the parties. Yes, next. Yes.
My lords, in this RPF, we are challenging the order passed by family court in criminal miscellaneous.
What is the amount granted?
Amount granted for 8,000 rupees per month.
8,000 per month.
Yes, please.
This is by the wife or the husband?
Please, please, madam.
No. This RPFC is filed by the husband or the wife?
Husband, madam.
Husband is questioning that 8,000. On what ground?
My lords, he earns monthly 2,000 to 3,000 rupees, my lords.
How much?
2,000 to 3,000. He runs a pawn shop, my lords, which was owned by his father previously, and the license is still in the name of the father. And the father, due to the family disputes between them and of the husband and wife, the present petitioner and the respondent, he had disowned them, my lords. And even in the trial court, my lords, in the family court, they have not produced. They have made up all contentions that that I am a big businessman and my father owns a big business. Whereas I.
Please come to the order.
Page number 46 of the appeal.
Come to page 40, para number 38.
Please.
Come to 40, para 40.
Please. Further, the petitioner has filed the affidavit of the assets and liabilities along with the salary certificate dated 9/1/2021 issued by the proprietor Sri Shekhara Associates, which disclosed that the petitioner working within the said company since July 2020 as part-time clerk and receiving the salary of rupees 3,000 per month. From this, it appears as on the date of filing the present petition, the petitioner was working with a salary of rupees 3,000.
Read further.
Further, it is contended by the respondent in his objections to the main petition that the petitioner is a BCom qualified and before her marriage also, she has worked as accountant in DTDC, courier company, Hubballi, by drawing a salary of rupees 15,000 per month, and now also based on her previous experience, she is earning of rupees 18,000 per month from the same company and on the same post at Hubballi. He has further contended that he is unable to get and produce the real salary certificate of the petitioner before this honorable court. It is because that where the petitioner is working now in DTDC, the courier company at Hubballi, is administered by Bhaskar Vedya, who is relative of the petitioner, and in spite of several requests made by him to Vaidya Bhaskar to give the salary certificate of the petitioner, he intentionally did not respond him and did not provide the same to him. So it appears that the Bhaskara Vidya, being relative of the petitioner, willfully wanted to hide the real salary of the petitioner so as to support her claim huge amount of maintenance from him in the court. He further contended that even the petitioner is well qualified, capable and experienced and a working lady on her own capacity, she is able to maintain herself even without depending on him. and her parents, and the petitioner is working lady, as admittedly by herself in the main petition. But it is totally false to say that petitioner is working as a part-time job holder and she is getting a salary of rupees 1,800 per month. He has further contended that it is intentionally, falsely, and very factfully mentioned in the petition that the petitioner is working as a part-time job holder and her salary is rupees just 1,800 rupees and so on to claim huge maintenance from him unlawfully and is to just harass him in this case. He has further contended that the fact that his father is running a small pawn shop by taking it on rental basis by paying rupees 2,500 rent
Yes,
every
heard the learned counsel for the petition in part, no representation on behalf of the respondent. Mrs. Martha tomorrow as partner. Yes.
One, there is another submission, madam. Subsequently, after the stay granted by this honorable court, the respondent has,
Stay is granted on what the condition?
my lords, to comply with the 50,000 rupees from 2 weeks of getting the order sheet, and subsequently 15,000 within 2 weeks of paying the 50,000, and they have met with those conditions. But they have further.
How you are able to met when your income is 2,000?
My lords, I have taken loan.
Yes, we will see tomorrow.
Please.
Yes, 40.
Still number 40. Other some of the hearing.
This honorable court has granted entry order of stay on 19/9/2024. Again, an order has been posted for hearing for stay today.
Marriage.
Please.
You said there is your seniors house, there is a marriage, you are asking for adjournment in the morning.
Serial number 4.
In your seniors house.
41. In serial number 41, I took adjournment.
In this you don't want adjournment?
No.
You are ready?
I am ready.
Please argue then.
Interim order has already been granted by this honorable court.
No, let it be, we'll hear it finally. Pass over. If you are ready, pass over. You are ready right now? Yes. Let's see, what is the amount that is granted here for the husband or the wife?
For the husband's petition.
How much is granted by the court?
The High Court granted 8,000 for the respondent number 1 and 5,000 each to the respondent number 2 to 4.
2 to 4 are the children.
Children. The marriage was solemnized
2 to
on
4 means? 2 to yes, so that is 15,000. So that is 15,000 plus 8,000.
23,000.
Use the mic.
All the 3 children staying with the red sister, and he's looking after all the children, 3 children.
Is it correct?
My lordship, on the last occasion I submitted that I will inquire with the respondent. The phone number which was given to me, I called on that, but it is invalid, my lordship. So I could not contact her. She
So
told
no,
me,
if the 3 children are staying, then that has to be excluded.
Yes.
And as far as the wife is concerned, will confirm.
yes, my lordship.
The wife is also suffering a conjugal rights order, and it has been finalized.
She has not joined the husband.
She has not joined the husband, my
It has
lordship.
Then on that ground, under 125, she is not entitled. When she is without a reason, and that too when there is a decree of restitution, if she has not joined the husband, then she is not entitled for
Her
maintenance.
say was, my lordship, the children are residing with her. On the last occasion, I requested the court to give some time.
So finally, please make your arrangements, or else we'll consider his submission and pass orders. This is matter on 13th of November.
11th, my lordship.
11th of November, at the
Please.
request of counsel for this morning. Yes, next.
Interim order earlier granted.
Intermodal earlier grant is extended till the next date of year. Yes.
Number 42. No, 59.
42, there are
Yes,
2
Martin.
petitions. 42, there are 2 petitions, one by the husband and one by the respondent.
Yes.
In fact, on last occasion, Lord, they gave a proposal that for one time settlement of 10 lakhs. I've conveyed it to the party. Could it, Lord, be adjourned by 1 week, so that, Lord, I'll keep the party present, Lord.
Like council submits that the respondent has come up with the one-time settlement of an amount of rupees 10 lakhs. The same has been he has communicated to the client for waiting for him so further instructions. It requires a week's time. This is matter on 13th. 13th. Yes, next.
Number 40. No objection to petition rights.
Previous session, the matter is likely to be settled for the reason that I am the husband. We have visited the respondent house, and they are ready to come on 8th of this month. We are ready to take her, and we will file affidavit after 10 days or 2 weeks time.
1 month time is granted for filing the affidavit.
Affidavit, so that after
It is submitted that the compromise talks are going on and it gets likely to be settled. Let's just matter on 9th of December.
yes, the model is
Into model earlier granted is extended. Yes, next.
Number 44.
So petition, my lord.
Yes.
My lord, Kannada, to furnish the translated copy, my lord.
At the request of learned counsel, the petition is this matter on 4/11. Were you sought time on the day? Is the court audible to you?
Please, my lord.
Yes, why the time was sought on the day? And
My lord,
why
I have.
yes. Anything is in Kannada?
Please, my lord. Impugned order at page 16. It is in Kannada, my lord.
Then how much time you require to find the translated copy?
4 weeks, my lord.
Then why you sought for on 23rd you sought only for a week?
My lord, I have petitions to present to that.
On 18th of December.
Great.
No further time will be granted. Yes, next.
My lord, may I make one submission in this matter, my lord. Before the trial court, my lord, see, he is, my lord, representing and saying that the matter is pending before the trial court. That is what, my lord, trial court was not pursuing the matter. To that observation, trial court may be proceeded.
Give that earlier matter 44.
There was no such stay, my lord.
Learned counsel for the respondent submits that though there is no stay by this court, still the court, as the matter is pending before the court, the trial court is not proceeding with the matter. It is made clear that as the no stay is granted by this court, the trial court is at liberty to proceed with the matter. Yes. Yes.
Number 45.
Just for the respondents, I also filed a CP.
What is that number?
CP number 100.
Take that post along with that tomorrow. Yes, next.
Make one submission. There are 3 matters pending before the background court. The two criminal matters.
No. He says he has also
He
filed.
is only seeking one matter.
No, that's fine. Is there any other matter?
The other 3 matters are there.
That's why we'll look at it and tomorrow let it be listed and we'll pass orders.
Interim matter.
Interim order earlier granted is extended. List along with so and so tomorrow.
Day after.
Day after tomorrow.
Yeah.
Yes, next.
Number 46.
Yes.
I filed a statement of objections today.
Today morning they have served the kind of weeks of time.
What are those big, what is this filed by the wife?
Vice
What are your objection to that?
Please, the wife is a resident, permanent resident of Shikaripur. I produced the Aadhaar card and the voter ID of the present petitioner.
No, please come to the prayer in this.
Please,
Transfer MC number, which is pending on Bagal Court to Davangere.
please.
So what is your objection?
Please, the present petitioner is not residing in the Davangere.
Uh,
And she is a permanent resident of Shikaripur, Shimoga. And she had filed an FIR also against the present petitioner.
When was it?
Please,
When was it?
the FIR was registered on 28/5/2024, and the principal bench, the present respondent had approached the principal bench by filing a criminal petition before the principal bench, and the principal bench has granted the interim order of stay of that criminal proceedings also. I have produced the documents also in terms of interim order. And thereafter, Your Worship, after filing of that FIR, Your Worship, she subsequently files a criminal miscellaneous number 43 by 2024. She for the office punishable section 12 of domestic violence act.
For the same court.
Same court, Dharwad. I also produced that document, Your Worship. And her contention was that Your Worship, she is
No,
suffering
you
from
are
the
saying
illness.
that she is a resident of Shimoga.
Shimoga. I produced the voter ID and Aadhaar card.
Oh.
And Your Worship, the
What is stated in this in the grounds before this court?
that she is
Onali
suffering
village
from
in Shikaripura Taluka of Shimoga district.
But in her address, Your Worship, kindly cross check her. She shows that she is resident of Onali, Davangere village. But the voter ID and Aadhaar card shows that she is resident of Shikarpur and
File your reply to that.
registered.
File your reply to that. Tell your client that if any facts are not, the true facts are not stated, then she has to face the consequences. The objections are filed with the respondents. The petitioner wants to file a rejoinder. List is matter on when. When?
Friday.
Huh?
Friday.
5 days.
Friday or not?
Friday. This is matter on 12th November. Yes, next.
Number 47.
So, Lord, this one RPFC has been filed by the husband and another one by wife. They have filed an application for vacating this day. I may be permitted to file necessary objection to the application. Even I am ready for.
Well, here, no, not required, no objection. Yes. How much is? Yes, password. Next.
47 password. Seal number 48. J. Shetty.
48.
48.
Yes.
For the petition.
J. Shetty.
2 days.
Why? Why 2 days time?
Citation is required. Some of the depositions are in Canada.
No, let's see what's the impugned order. Then we'll think
Impugned
about
order is not-
whether the court has to look at the depositions or not. Please come to the that.
The suit is under the provisions of the Karnataka Small Cause Courts Act.
Karnataka?
Small Cause Courts Act.
Uh.
For the eviction of the petitioner's area, on the ground that there is areas of rent by him. That is only on the ground. The notice was issued, quick notice was issued. It was replied by the petitioners. And during the course of in the evidence, they admitted that there is no areas of rent as such, and the rent has been paid up to. Only ground on which the eviction suit has been filed is the areas of rent. Then, notwithstanding that, trial court has declared this.
Let's see the finding.
Yes.
Specific issue was filed with regard to areas of filing.
Let's see the issues.
Issue number 3 is the specific issue.
There is an admission on the part of the PW1 saying that there is no.
Issue number 3 is where the plaintiff proves that the defendants are default of payment of rent.
It is answered in
Owner of ground area. Defendant. So the only ground is as stated by him. That's the only ground.
That's only the ground.
That whether there are any areas of rent or he is at default. Then you agree that that he is not at default.
no, Malad, he default. Therefore,
Come to the findings.
please,
The admission on the part of.
Where is that? Where is that which you find it in the order?
Your Lordship, page number 32. He admits, page number 32, para 60. Further, as per the pleadings and evidence of the plaintiff, the defendants are monthly tenant of the plaintiff through the suit or scheduled property, and the monthly rent is 137.50 per month. Whereas defendant contended that is a yearly tenancy, the rent of the property is 1,650 per month. The learned counsel for the defendant vehemently argued that he confronted the rent receipt to the PW1, and PW1 admitted the same, and those documents are marked as Exhibit D1 to D10. In this receipt, it is mentioned as yearly rent of rupees 1,650.
ಪ್ರತಿವಾದಿಗಳು ಪ್ರತಿ ವರ್ಷ 1,650 ರೂಗಳನ್ನು ಬಾಡಿಗೆ ಕೊಡುತ್ತಾ ನೀಡುತ್ತಾ ಸ್ವಾಧೀನದಲ್ಲಿರುತ್ತಾರೆ. ವೆರಿ ಸರಿ. It's categorically admitted that they are paying the rent.
Yes, Mr. Counsel, what is it that's in Kannada?
ಸಾಕ್ಷಿಯು then
No, please tell the court what is that in Kannada?
That's it. The defendants are not paying rent of rupees 1,650 on a yearly basis.
is correct. ಸ್ವಾಧೀನದಲ್ಲಿರುತ್ತಾರೆ ಅಂದರೆ ಸರಿ. He admits that.
So you take a stand that it is not a yearly rent, but it is a monthly rent of 1,650, and they are into arrears.
Therefore, one can see minutes further.
And Malad, even
may I read minutes entire? And thereafter, page number, internal page number 16.
Therefore, 6 months notice is required.
Is required. Even it is considered as a yearly tenancy, it is admitted that between the parties, the plaintiff filed provisions previous case under so and so, the same has been withdrawn by the plaintiff with the permission of the court to file fresh suit. As such argument of the learned counsel for the plaintiff before filing this case, the notice was issued to the defendant. Thereafter, again before filing the suit, notice was issued to the defendant. The said notice is issued by the defendants on 13/10/2017. The case is filed on 2/12/2017. Looking to the pleadings of the both parties prior to filing the case, that is SC number 3 of 2013, notice was issued to the defendants with the permission of the court. This case is filed. Even then, they have not vacated the suit. Again, before filing the case on 10/10/2017, plaintiff issued notice to the defendants. On the said notice of the defendants have given reply to the plaintiff on 26/10/2017, which can be seen from the exhibit P3. And
No.
Let's take
Please
the
come
next.
to, no, I've seen. Before point number 3, at page number 17, court comes to the conclusion that it is a monthly rent.
There is a findings of the trial court. In the
That finding only I have read.
The suit is filed on so and so much. May I read what's kindly seen this? Further, defendant himself confronted rent receipt, which shows that the rent for the year 1 to 2000.
That I have read, the entire para I have read.
Next one. If it is yearly tenancy.
That's what I'm saying, Mr. Counsel. I have read the entire para of 16, where it says that court comes to the conclusion that it is not a yearly tenancy, but a monthly tenancy, and 15 days notice is sufficient. Now, when you yourself admit that it is a yearly tenancy, why should the court assume something?
No minutes.
No, please again come back to the Kannada version.
Please.
Reading that, do you agree that whether the landlord has admitted the fact that it is a yearly tenancy or not?
The interpretation of this plus Kannada is they are the defendant, the present petitioner.
Let's not go into the interpretation. Please just, because the court can't understand, please read that version of Kannada.
The reason for that paying is monthly tenancy is it comes around 137 rupees per month. That's why they are paying on yearly terms. This is the only.
And it's been happening from several years. So that means that's the accepted norm between the parties.
No, even therefore, subsequent even before completion of year minutes, you have
no, Mr. Counsel, please understand. I understood what your submissions are. Court, you have to tell the court what does it mean. What is the meaning of this Kannada thing at page number 32? Please read it.
ಪ್ರತಿವಾದಿಗಳು ಪ್ರತಿ ವರ್ಷ 1,650 ರೂಗಳನ್ನು
For that sentence, till full stop, you read and tell the court.
ಪ್ರತಿವಾದಿಗಳು ಪ್ರತಿ ವರ್ಷ 1,650 ರೂಗಳನ್ನು ಬಾಡಿಗೆ ನೀಡುತ್ತಾ ಸ್ವಾಧೀನದಲ್ಲಿರುತ್ತಾರೆ ಅನ್ನೋದು ಸರಿ. What he says that by paying 1,650 per year, the defendants are in possession of the property.
Next sentence.
ಈ ಬಗ್ಗೆ ನಾವು ರಸೀದಿಯನ್ನು ಕೊಟ್ಟಿರುತ್ತೀವಿ ಎಂದರೆ ಸರಿ. But he also admits that yes, issued the receipts are grounds on which the eviction is are.
Please come to that petition.
That is page number 50.
Page number?
Page number 50. It starts number 55 and 59 may can be seen. Suit is for recovery of possession and also for recovery of areas of rental of ₹9,075 and yearly rental.
You are reading at para 5?
Yes, para 12.
Read para 5.
para 5. That the dependents are inducted in possession of the suit property by the plaintiff as a tenant, and tenancy of the tenants from first day of each month and ends on the last day of every month. The dependents have agreed to pay the monthly rental of rupees 137.50 without any delay and default. But dependents have failed to pay the monthly rental properly as and when the same has been fallen due. Further, it is submitted that the dependents have committed default in payment of rental of rental of the suit property to the tune of rupees 9,075 from 1/4/2012 and 39/2017, and also the future rental, and thereby have violated the terms of the lease.
So,
But this is also
your very
falsified.
pleading is contrary to what you have said. Now you are taking two different stands. On one stretch you say that 1 lakh, 1,37,000.
137.
So what is that? 137.50 is your monthly rent. When it comes to your admission, you say that it is a yearly rent. Then thereafter, now your stand is, though it is 137 so and so, every month he has to pay so and so, that he is not paying. That's why on that ground he has to be evicted. How all these things are, this contra pleadings.
Even otherwise,
Not otherwise. It is in a suits of this nature, parties are governed by their pleadings. What is your pleading? Then your suit itself has to go with these pleadings. You say that it is 137,550, whatever it is, you call it 1,37,000 or 1,037, I don't know. That is a monthly rent according to you. You admit now that it is a yearly rent.
no, that is not my case.
Huh?
We are receiving per year.
No, please come to I'm looking at your pleadings. The defendants have agreed to pay monthly rental of rupees so and so.
The monthly rental.
What is that monthly rent? How much it is?
137 rupees.
137 rupees is in one. Look at it. Is it 137 rupees?
There is a mistake in the minutes. But 137 minutes, even minutes, 1,650 divided by the 12 minutes, it comes around 137 rupees per day. That's why it is in small quantity. Therefore, we are receiving the entire amount
In advance.
on advance.
Maladi, that is the case. Advance rent amount has been received by them. They admit it. The question of Maladi area should not exist. Apart from that, another aspect Maladi is also required to be considered. Is that the petitioner Maladi is a trust. But Maladi stated that the power of attorney has been executed by another person, and on the basis of the power of attorney, Maladi this suit has been filed. No permission has been obtained at the time of institution of the suit. Maladi has to file it.
Where is his notice?
The notice is Maladi
Filed?
not filed. It's not. It's in the record. Maladi.
Records are there.
Record. Order to be secured.
Huh?
So, no records.
Yes, this is directed to call for the floor court record. It's there. It is there. Take out the notice. As marked as exhibit.
Oh, Maladi, it is exhibit.
Exhibit P3.
P6.
P3 is the legal notice. Maladi, exhibit P4 is the decline. And another aspect, Maladi, is also Maladi relevant, because suit Maladi is said to have been filed by a trust. The person who has Maladi executed a power of attorney is by an individual, not by a trust. And on the basis of the power of attorney, Maladi the suit has been filed. Exhibit P1 is the Maladi GPA. GPA, Maladi is altogether a different person, not by the plaintiff.
In para number 2, we clearly mentioned that monthly rental is 137.5.
So where is the evidence to show that you have paid the rent from 1/4/2012?
Exhibit D1 to D2.
Huh?
Exhibit D1 to D2. It is confronted to the PW. It is admitted. They say that it is admitted and advance rent is being paid every year. And in the presence of this evidence, to show that already been paid. The question of
that evidence is in
default
Kannada. That evidence is in Kannada.
Yes.
Please place before the court the translation.
Another aspect, the suit has been said to have been filed by a trustee. Now kindly see the exhibit D1. It is a power of attorney, stated to have been executed by one Swami in respect of the property belongs to Mursaramai, not in respect of the property belongs to plaintiff. So very foundation on which the suit has been filed will also go.
That aspect also will consider. The counsel of the petition is added to place before the court the translated copy of the evidence of defendant number
PW1 as well as
PW1, yes.
Including PW1. Including
Yes, PW1 and PW1 both. And list is marked on when? 20th? Yes. I think till such time, the list has also come. Till such time, the respondent shall not take any coercive steps. Yes.
My lord, I'm representing respondent, my lord.
What is that?
Respondents.
Respondent.
What do you
my
want?
lord, my lord, Honorable Court has ordered on 27/9/2024 to the petitioner to file an affidavit with respect to the assets and liabilities, my lords.
miscellaneous in OS number so and so, on the file of so and so till the next date of hearing. Petition is permitted to take out and summons on the counsel applying for respondents and file a memo to that effect by 25th of November. The registry is also directed to issue notice. Yes.
Okay.
Yes, next.
In respect of other respondents, that is the official respondents, the government may kindly be directed to take it.
In
Respondent
respect
6 and
of
7.
respondent number
6 and 7.
6 and 7. Generally, like in the writ jurisdiction in the civil matters, you cannot direct them to take notice. It has to be by way of notice. Yes. Next.
The present petition is for the transfer of the petition.
Use the mic. Yes.
The present petition is for the transfer of the petition MC number 66 of 2024 from the Senior Civil Judge Court, Kundapur, to the Jurisdictional Court of Haveri, Mumbai.
What is the distance? Distance.
180 kilometers.
This is a petition by the wife.
Wife.
When is this MC filed?
MC was filed on
Criminal miscellaneous.
2/7/2024, my lord.
On?
2/7/2024, my lord. Just before that, on 22/4/2024, my lord, a petition of criminal miscellaneous was filed by the wife as well for the maintenance, my lord. Just after 2 months, he has come up with this.
He has filed MC before the courts at Kundapur.
Kundapur, my lord.
And you filed criminal miscellaneous.
The wife, my lord, the petitioner, my lord.
First she filed.
First she filed, my lord. After 2 months, he has filed, my lord.
Only the
Just
two
to
matters are only 2 matters are pending. MC
Yes,
and
my
criminal
lord. Yes, my
miscellaneous.
lord. One in Haveri and one in
The present petition is filed seeking transfer of MC number 66 of 2024 pending on the file of the senior civil judge at Kundapur, the Udupi district, to the family court Haveri. The facts of the case are that the marriage was organized on 13/4/2022. In view of the disputes between the parties, the petitioner wife on 22/4/2024 had filed criminal miscellaneous 59 of 2024 seeking maintenance before the family court at Haveri, and in that summons were also issued to the respondent husband and he appeared. Thereafter, he filed MC number 66 of 2024 before the senior civil judge court at Kundapur for restitution of conjugal rights. And in that matter, summons was served on the petition to appear on 6/8/2024. Then counsel appearing for the petitioner submits that the distance between both the places is 180 kilometers. The wife is staying along with her parents in Haveri, and it's very difficult for her to travel to Kundapur on every date of hearing. And hence, she requests court to withdraw the MC 66 of 2024 pending before the court at Kundapur and transfer the same to the family court at Haveri. Notice is next para notice is served on the respondent. No vakalat is filed on his behalf. Next para having heard the land counsel the petitioner for whose entire material on record. Considering the fact that all DM's criminal miscellaneous number 59 of 2024 is pending before the family court at Haveri. And further, considering the convenience of the wife, this court deems it appropriate to withdraw MC number 66 of 2024 before the senior judge pending before the senior civil judge at Kundapur and transfer the same to the family court at Haveri. Accordingly, petition is allowed. Yes, next.
Yes.
Vice petition, taking transfer from Kerala to Belgavi. Distance is 55 kilometers. Wife had filed criminal miscellaneous number 298 of 2022 on 23/9/2022. Thereafter, after a lapse of 8 months, the husband has filed MC 23 of 2023 for restitution of conjugal.
What is the stage now of the MC?
MC notice has been issued to the
The present petition is filed, seeking transfer of MC number 23 of 2023, pending before the senior civil judge, okay, to the principal judge family court, Belgavi, where the criminal misdemeanor number 298 of 2022 filed with the wife is pending. The facts of the case are the parties, the marriage had taken place on 12/5/2014. In view of the differences between the parties, they starting separately. On 21/9/2022, the wife had filed criminal misdemeanor number 298 of 2022 for the principal family judge Belgavi for maintenance. In that, the respondent had appeared. On 1/4/2023, the husband had filed MC number 23 of 2023 before the senior civil judge court of Kerala, seeking restitution of conjugal rights. Now, in that, a notice is issued to the wife. The wife is before this court stating that it's difficult for the wife to travel all the way to the family court at Ukeri, and there is a threat to the wife, and the distance is 55 kilometers. Further, it is stated that in fact, the criminal misdemeanor is instituted by the wife in the year 2022 itself. Next para, no notice is served to the respondent, there is no representation. Considering the fact that the wife had already, having heard the counsel for the petitioner, there is a material on record. Considering the fact that already the wife had filed criminal misdemeanors on the file of so and so, this court deems it appropriate to withdraw so and so from so and so and transfer the same to so and so. Accordingly, CP is allowed. Next.
the wife appeared and nothing was referred for conciliation.
In that MC filed for restitution, the wife appeared. In the facts, you record that. The matter is referred to the mediation. Yes, next.
Wife petition was seeking transfer from Kalburgi to Ranagaram.
Kalburgi to
Ranagaram.
What's the distance?
More than 400 minutes.
And when is the MC filed?
My lord, MC was filed in the year
2023.
2020.
What is the stage now?
My lords, the petitioner was placed ex parte, my lords, and the evidence has commenced, my lords, and arguments of the petitioner in MC was over, my lords.
Then why will we do it now?
My lords, we are
what are you doing?
Lords,
When you have received the notice, why you didn't appear?
my lords, wakalat was filed on behalf of the respondent, my lords. My lords, that wakalat was rejected by
Even have you filed any application to set aside that ex parte order?
We are seeking, that's why we are seeking for transfer of the matter, my lords. My lords,
So
she has a
till
baby
the matter is transferred, you will not file an application.
My lords, she has a baby of 2.5 years, my lords, and she is not keeping well, my lords.
When did
And
you
she's
receive notice?
residing at the
No, when did you receive notice?
My lords, notice was received.
No, we will not waste the court's time on any of these grounds. Please get instructions. When is the notice received by her from the family court? And whether an application to set aside the ex parte order is filed or not. And will not extend any relief for her with this petition. Please get instructions. This is matter day after tomorrow as part. Yes, next.
Stay may be extended, my lords.
Interim order granted is extended till then.
Okay.
Yes.
Wife's petition, my lords. Seeking a transfer from Koppal to Bangalore. There is a
Koppal to Bangalore. What's the distance?
350.
What's the reason?
My lords, so now the petitioner is staying in Bangalore, my lords, with her son. She is working there as a maid and staying with her son. There is a likelihood of settlements, my lords. My matter may currently be referred to mediation. Today only they have offered for, today only they have offered for settlement matters. I'll talk to my client and.
It is submitted by the land council that there is a scope for settlement. Shall refer it to the mediation or you will get instructions?
Can be referred to the mediation.
It is submitted that there is scope for mediation. Both the parties shall appear before the mediation center on which date? On 13th?
11, my lords,
11?
11.
On 11th. Yes, next.
Interim order may kindly be extended.
Interim order earlier granted is extended to the next date of hearing.
On the petition, transfer petition, by the wife.
Where is the counsel for the respondent? Inform him, pass over. Pass over.
Petitioner is seeking transfer from Hubli to Badalpur district. Distance around 122 kilometers.
When is the MC file?
Filed on 27/6/2024.
24.
Is a live threat on the life matter. You can file a complaint under section 5 of 498, 5 of 4, 148, 333, and as well as section 3 and 4 of the right.
The present petition is filed. To transfer MC number 281 of 2024, pending on file of the first edition Principal Judge Family Court of Hubli, the code of the Principal Judge Family Court, Badalpur. The facts of the case are marriage between the parties formalized on April 2021. When was the difference between the parties on 21/6/2024. The wife had filed a complaint before the Badalpur Women PS against the husband, and the same is registered for the offences under section 506, 498A, 504, 149, 329 of the IPC, and also for the offences punishable under section 3 and 4 of the Dowry Prohibition Act. Thereafter, on 27/6/2024, the husband had filed a petition under seeking divorce, that is MC number 281 of 2024, on the file of the first additional Principal Judge Family Court Hubli. The wife had also filed criminal miscellaneous number 74 of 2024 on the file of the Principal Judge Family Court Badalpur, seeking maintenance of an amount of rupees 25,000. The ex-parallel counsel appearing for the petitioner submits that she has been harassed by the respondent and the family members, and there is a threat to her life. She is residing along with the parents who are suffering with old age elements, and they are unable to manage with their day-to-day works, and they are not in a position to accompany with her. And the son, who is of a tender age, he cannot be left alone. Hence, this sought for the transfer of the pending MC on the file of the family court Hubli. It is also stated that the distance between both the places is 120 kilometers, and it's very difficult for her to travel. Though notice is served on the respondent, there are no wakalat filed on his behalf. Considering the fact that the criminal case is registered at it's Badalpur. Is that? It's Badalpur, and also her petition seeking maintenance, that is criminal miscellaneous number 74 of 2024, is also pending on the file of the family court, Badalpur. This court deems it appropriate to withdraw MC number 281 of 2024 on the file of the first edition of Principal Judge, Family Court, Hooghly, and transfer the same to the Family Court, Barber Court. At Barber Court, accordingly, petition is allowed. Yes, next.
Yes. Wife has filed a petition, transferring the petition from the family court to Belgaum family court.
Hooghly to Belgaum.
Hooghly to Belgaum. Husband has filed direct petition in MC number 457 of 2024.
2024? Oh.
20. And apart from my ground for seeking the transfer of this petition is first of all that the other petitioner has already filed a harassment case against his respondent under section 498, 323 and 504 formalities in the year 2016. And thereafter maintenance petition was filed which is allowed, and now the recovery petition is also pending, and one revision petition is also pending.
And all of them are at Hooghly?
In Belgaum.
Oh, you want it from Hooghly to Belgaum?
And other ground for this, she has one child who is age about 8 to 9 years.
The then counsel petitioner submits that the petitioner is residing at Belgaum and the husband has instituted the MC at Hooghly. Already she has filed a criminal case at Hooghly and also at Belgaum and also a maintenance case at Belgaum. And it's very difficult for her to travel. Considering the same, they shall be stay of all further proceedings in MC number so and so till the next date of hearing. The petition is permitted to take out notice on the counsel appearing to the respondent before the trial court and shall file a memo to the defendant. Mrs. Marta, hand summons. Mrs. Marta on 26th of November.
Obliged.
case held up in court hall number 8. The appeal matter.
It is held up in a court hall number 2 by 2 days, tomorrow. Yes. Yes.
Number 47.
At the request of the counsel, the petition, this is matter tomorrow. Yes.
Number 47.
Yes. Yes.
First petition, I appear for the respondent. So I appear for the husband, wife, So I have filed petition seeking from questioning the order of the trial court, rejecting my petition. On the ground that voluntarily I have left the company of the husband. The other reason is that I am engineering degree holder. Therefore, I am capable of earning the money, which is contrary to the material, which in fact has not been produced before the court. She has not completed her engineering. She has some subjects in third and fourth semester. She has not completed. So far as their petition is concerned, that is filed questioning the quantum of the amount which has been granted to the child.
How much is granted?
10,000 is granted.
What is your income?
I appear for the wife.
You appear for the wife. How much is the income of the husband?
Nearly 50,000. He is working as a clerk in Bank of Indian Bank.
So according to you, 10,000 is more
Yes,
to the children.
Yes, ma'am. And moreover, she has not been granted this maintenance, saying that on her own volition she has left the matrimonial home immediately within 22 days of the marriage, ma'am. And it is admitted fact also. She has clearly admitted that she left the matrimonial home, and her main allegation is my party is having illicit relation with his own sister-in-law. They are living in joint family. Because of this lady, entire family is destroyed.
No, it's not going to all that. Now, why according to you, the maintenance that is granted to the children is on the higher side?
Yes, my lord. Because his only income is nearly 50,000 as a clerk, and moreover, he has availed a loan which is admitted by her also for getting a side, and he has withdrawn this one availed OD benefit for the family maintenance, and he is paying that also deduction, and it is a reasonable deduction. He is not claiming anything, and he is maintaining his age-old mother, and his sister's husband has died in this one corona. And he has to maintain his sister along with 2 children. Yes.
And what about your children?
Yes, that's what. He's paying that 10,000, He's paying that 10,000.
But you questioned it.
Yes, my lord. 10,000 is on the higher side because on her own volition she has left the matrimonial home.
On her own volition, if she has left, the court has not granted to her.
Yes, my lord. She has challenged that also.
But to the children.
And at the cost of the child, she is enjoying the maintenance. 10,000 is on the higher side. That's what I have challenged.
Yes, please argue on the wife's maintenance.
Yes.
Please come to the finding of the court on that aspect.
There are 5 listeners the finding of the trial court.
Please read.
That's why the
Please read.
relevant portion is at page number 18. That the
Page
petition
number 18.
18. In second line that the petition number 1 called her parents, and without leave of the respondent and elders, she left the matrimonial house.
You're reading where 18 is the second para.
No, the internal page 7 of the judgment.
That is 23 page. Yes.
I'm sorry. That the petition number 1 called her parents, and without the leave of the respondent and elders, she left the matrimonial house on 22/1/2020. Thus, the petitioner number 1 willfully deserted the respondent. The respondent further pleads that on 27/1/2020, the petitioner number 1 informed the respondent over the court that she has become pregnant. The respondent and his family members were surprised to hear and said news as the petitioner number 1 herself stated before the relatives of the respondent that there was no sexual intercourse between them. That consequently conciliations were held on 3/2/2020 and also on 22/2/2020. In those conciliations, the petitioner number 1 was adamant and she put forth the further demand which the respondent could not accept. Therefore, the petitioner number 1 refused to leave and lead like the respondent, besides expressing her inability to join the respondent, that on 10/6/2020, petitioner number 1, her parents and other 15 unknown persons have visited the house of the respondent in Bengaluru City and made galata by abusing the respondent and his family members, and they even tried to manhandle his brother and other members of the respondent's family. Here, except Miller's making allegations. Please. That the respondent's family was rescued by his neighbors, that petitioner number 1 has been insisting the respondent to leave his job or to get transferred to the place of Ballari and to reside at his parents-in-law's house. The respondent does not deny.
Any matrimonial proceedings are pending?
One Miller's proceeding he has filed for seeking for divorce, which has been.
That's pending.
No, it's decreed.
It is decreed.
And he has challenged.
I have challenged it, Miller's. The appeal is pending before this honorable court.
It's on the ground of desertion.
Create,
not on desertion.
No, madam. But this divorce has been granted on the ground of trade.
That's the family right of Miller's, both the parties, even according to them, it is only for 22 days. In 22 days, Miller's, as many as Miller's, 4 reasons have been pleaded Miller's by the husband. One is Miller's that she wants Miller's, the husband, to take transfer and go to Ballari and reside there. The second one is Miller's, she has made allegation that Miller's is important. The third allegation is that Miller's, she is not ready to cook a proper food. But these are all the allegations, Miller's. This is Miller's admittedly 22 days married life. And moreover, Miller's, first time Miller's, as it is Miller's are aware that Miller's after marriage is always Miller's obvious that Miller's every lady after some time wants to go back to her parents' house for some time. And reside there and once again Miller's will come and join the house. Here, Miller's, the respondent himself has accompanied her and her father to the bus stop in Bangalore. He dropped them at a bus stop. And if at all there is any dispute or any allegation against the wife, he could not have accompanied them to the bus station. The court says that will not that is not the issue where the court can presume that there is no dispute. Lordship, you kindly come to my lordship. There are 14 of the judgment. That the finding of the trial court is not recorded. Above being the specific pleading in para 9.
No, okay. What are these findings of the family court in a divorce petition, in a maintenance petition? I mean, like the court can grant divorce on these findings. If you look at para 18, para 19,
yes, I'm
most unwarranted findings that are given by the court.
No, I may be permitted to read her evidence, my lord, in these.
No, that's true. The divorce is pending. It's not even your case that she has deserted you. That's why I asked you on what ground you filed for divorce.
No, immediately after deserting me, like going to Ballari, that is to her parental house, immediately she lodged this one dowry harassment case and maintenance case one by one. In spite of many mediations, she has not turned up. And her main allegation, even in the evidence is, my lord, I will be permitted to read it. I said that the respondent is having illicit relation with one Jabin, wife of Riyaz, who is none other than the sister-in-law of the respondent. This is her main allegation, and she herself left the matrimonial home. And after divorce, now she says that I want to come back. On her own, she has left the matrimonial home, and section 125 subclass 4 of CRPC is very clear that no wife is entitled for maintenance if she herself leaves the matrimonial home.
So, for that, there should be a finding.
Yes,
Where
my
is?
lord. Yes, my lord. It is there.
In the divorce proceedings, there is no such finding.
No, it is there, my lord. No, the divorce paper, this one also it is pending and yes, my
In
lord.
that, no, in this summary, unless and until a competent court decides
Yes, my
that
lord.
there was without a reasonable cause, she is staying away from the husband.
Yes,
In
my
a
lord.
125 proceeding, just like that, there can't be any
No,
finding.
in para 14, the Honorable Trial Court has clearly held that the petitioner number either in a pleading or by way of giving voluntary answer or by way of suggestion mentioned nothing as to for what purpose she was constrained to leave her matrimonial home on so and so day. And even in her evidence, she has clearly admitted that she herself has left the matrimonial home.
As on the day this order is passed, divorce is granted or not granted? Not granted. During the pendency of the divorce proceedings, this order is passed.
That I have to go through that file, my lord.
So, like all these findings are beyond the scope of this petition.
Yes, my lord. I may be permitted to a week time to get all these documents and submit. And moreover, no, my lord, because recently she has lodged again each and every time she goes to his workplace and makes galata and lodges complaint. This is her habit. Recently on 16/8/2024, she has lodged one more complaint. Every now and then she goes to his workplace, makes galata, lodges complaint, and then she says she wants to come back.
That's what.
And this adultery allegation, main is adultery allegation.
No, the scope of
Making all this allegation, can we leave it that? Why? This is the question, my lord.
For granting maintenance, these allegations.
Yes, my lord, that point I will come. On her own, since she has left the matrimonial home, and she is in her pleading.
She has her own reasons to leave the matrimonial home. Everybody who leaves the matrimonial home, 125 under 125 CRPC, there is no law which says that they are not entitled for maintenance. Now, if a wife is leaving away from the husband, she has her own reasons. For that, she need not take husband's consent to leave.
No, reason is she has clearly mentioned all this allegation, and now again she says that she wants to come back. If my party is such a man, why she wants to come back? That means she has made false allegation. And one more thing, section 125 subclass 4 is very clear, my lord. If she on her own volition, if she leaves matrimonial home, she is not entitled for maintenance.
No, that has to be understood and interpreted in a manner. And if that's the case, in every case,
yes,
when there are disputes, wife will leave the house. In the then she is not entitled for maintenance.
No, my lord. Many a time, this one mediation was held. Even here also mediation was held. She has not turned up. Not even a single time. Many a time this matter and including that MFA was referred to mediation, but she has not turned up. She has not appeared before mediation at all.
Lordship may kindly consider.
So you have
within a short period of married life, whether a wife can be expected at least to make all these allegations.
And you forget about all that. Now in MFA and this matter, mediations were done. Yes. If that's your intention to come back or whatever you want, have you appeared before the mediation center?
No, subsequent because first time now I have appeared.
No, court has to assume that
some other advocate was
client is your client. Your client is one and the same.
Or else, my lords, may kindly, my lords, refer the matter once again for mediation. My lords, I will see that, my lords, comes before the mediator and let them have, my lords, once again.
For the petitioner submission, there is scope for mediation. Both the parties are directed to appear before the mediation center on 13th November. Yes.
Please.
16?
57?
The council is appearing to VC.
Yes, where is he?
Such Dharwad?
Yes, Mr. Counsel. What is this petition about?
Lord, this is a transfer petition filed by the wife.
From where to where?
From Belgaum to Bagalkot.
What's the distance? Distance?
150 kilometers.
Which year is the MC? Which year is the MC?
My lord, on 2/3/2024.
You said how much is the distance?
150.
Oh, please come. Let counsel for the petitioner submits that the husband has instituted MC number 017 of 2024 on the file of Family Court, Belgavi, Principal Family Court, Belgavi, and the petitioner is a resident of
Bagalkot.
Bagalkot. The distance between both the places is 150 kilometers. Considering the submission, there shall be stay of all further proceedings.
No, stay.
It's already there. The interim order earlier granted is notice is not ordered. Notice is not ordered.
Not issued.
Then nothing if the cost table doesn't contain 50.
Still number 57.
57.
Oh, 57. You for the petitioner.
Petitioner.
Respondent, where is the respondent at the case?
My Lord, he's appearing. I called him, my Lord, he's appearing.
You know, will allow it. The present petition is filed to transfer of MC number 117 of 2024, pending on the file of the Principal Judge Family Court, Belgavi, to the Court of Principal Judge Family Court at Bagalkot. The facts of the case are the respondent here, the marriage has taken place. Nothing has been stated in your affidavit, no facts, nothing. Any of the differences between the parties. The respondent here had filed a petition for divorce. That is MC number 117 of 2024 on the file of the Principal Judge Family Court, Belgavi. The wife is staying at Bagalkot. It is the case of the wife that she's staying along with her parents at Bagalkot and the petitioners and the parents and their poor persons are not able to maintain the petitioner, and even her traveling expenses have to be borne by them. And it's very difficult for her to appear before the courts at Belgavi on each and every date of hearing. As well, and counsel appearing for the petition submits that will transfer, Mr. Counsel.
Submission madi.
Is the one.
No, sir. Serial number 57 appearing for the respondent's notes, but unable to hear from the court.
Court is not audible.
Shabat. Dharwad.
We'll transfer the petition. Something wrong from his side. Is the court audible to you?
Hello. Yes, Virat.
We will transfer this petition. We will allow this petition.
Notes, my only objection may kindly be noted that the present transfer petition is filed. First, notes the respondent has filed the MC petition at the Belgaum. Subsequently, the maintenance petitions came to be filed in Bagalkot, notes. And further, she has contended regarding her financial duress. In card number 5, she has admitted that she is pursuing the job, notes. So, considering the same necessary orders.
And considering the convenience of the wife, the matter may be transferred to the wife had stated about the financial difficulties, and at the same time she says that she is working and she has taken a contrary stance. Then counsel submits that the wife had no difficulty to travel to Belgavi, and there are no reasons to transfer the case. Having got the land counsels on either side, there is some achievement on record. there is no dispute about the fact that the wife is staying at Bagalkot and the husband is staying at Belgavi. The wife has stated about her difficulties to travel, considering the distance, and also about the financial conditions. Even if the submission of the husband is taken into consideration, still the convenience of the wife has to be taken into consideration. And considering the fact that the distance is above 150 kilometers, this court deems it appropriate to allow this petition and withdraw so and so from so and so and transfer the same to so and so. Accordingly, petition is allowed. Next one.
Yesterday in the morning, the council of record on the petition has to travel from Bangalore, so he was not able to do it before today.
What has happened on the last occasion?
He has requested the matters to
Kiran Road?
immediately after Deepavali vacations. Request for
At the request of the council for the petition, this is matters on 4/11.
Before that also on 16th, it was
Interim
adjourned.
order
on this
granted
request.
earlier is extended till the next date of hearing.
One
Why
last-
every time he wants time?
The thing is, your worship, he has to travel from Bangalore.
When is he coming?
On 19th, yes, either on 19th or 20th. your
That
worship.
much
Your
time,
worship.
you cannot wait for it.
Your worship.
This is matter on the.
Any other date? On
Yes.
Your worship.
Yes, Your Lordship, my senior is held up in Court Hall 13, Your Lordship, is on his legs. Therefore, journey.
No, like you want 19th will not be granted.
Lords, I will not bother much.
Yes.
That's what the issue here is.
No, that's what we'll hear them and you will hear you also. We'll take
Short adjournment will be given on 7th minutes. On 11th, on 12th minutes. On 12th.
12. List on 12. No further adjournments will be granted. Yes, next. Yes. Interim order granted is extended to then. Yes, next matter.
Respondent wife has filed a petition under 125 claiming maintenance. And during the pregnancy of the same, she has filed a petition under DV Act claiming maintenance. The application under DV Act is allowed and 5,000 is granted towards interim maintenance. On 11/9/24, again the family court has allowed the interim maintenance application and has granted 20,000 per month to the wife nurse. But the settled principles is Rajnish versus Niyam Lutz. Even though wife is entitled to claim maintenance in multiple statutes, but the husband cannot be made to pay maintenance in each of the proceedings. That is
No. No, what is your income?
But his net income is
What's your income?
29%. He is working as SDC. Second is on clerk.
That was considered.
That is considered by the DV in the DV Act.
No, let's see the impugned order.
In the impugned order, it is not considered.
Let's see that.
The impugned order is at page number 41. Operative portion is at page number 46 of my petition. The wife states that my income is 50,000.
You didn't appear.
I have appeared.
Then you didn't file anything.
I also have filed my objections to that. But the court will have not considered my objections to that. Neither it has considered my income. 50,000 is what is claimed as the wife.
No. That in respect to the respondent, wherein under it discloses that respondent is working as STA and is earning 50,000 per month, having 2 houses in Gadag city, and also is given on rent of so and so.
No.
Have you filed your statement of assets and liabilities?
Yes, I have filed minutes. That is considered in the DVR proceedings.
Not DVR proceedings, sir. In these proceedings.
In that proceedings, I have not filed minutes.
Then if you don't file what is to be done, then an inference has to be drawn against you, and whatever the court will do.
But in settled principle of law.
No settled principle. First of all, you have to follow the principle, then you can ask for that.
But minutes, page number 91 minutes for a minute.
It is not that one proceedings you will participate and other proceedings court had to look at the earlier proceedings and pass orders. Yes.
Page number 91 minutes. There it has considered minutes. But the net salary is 29,043 rupees. They are showing it, his medical expenditure at 49,000 and his medical expenses at 11,125.
So you're around 30,000 you're earning.
Yes, around 30,000 I am earning much. I am regularly paying under vide at paying maintenance on every occasion.
Then pay 5,000 in this. The counsel, the petitioner submits that his income is 30,000, and out of that he is already paying an amount of rupees 5,000 in the other proceedings. The court, without considering all that, granted an amount of rupees 20,000 as maintenance, considering the submission of the legal counsel. There shall be stay of all further proceedings on the condition that he shall deposit an amount of rupees 7,000 by 5th of every succeeding month, and the arrears at rupees 7,000 from the date of petition till now, shall be paid within 8 weeks from today. Either he fails to pay the 7,000 or the arrears, the stay granted by this court shall stands vacated. This matter on 26th of November. The petitioner shall take out hand summons on the counsel appearing to the respondent before the trial court and shall file a memo to that effect by 21st of November. Even if the memo is not filed, the stay granted by this court stands vacated. Yes, next.
Number 64, number 63.
Yes.
The last occasion I have sought for time fellowship, but it became infectious. When parties have not turned up, as I am seeking them from, I sought the certified copy of settled.
The counsel for the petitioner submits that the matter is settled between the parties.
MC 107 of 2015.
107 of 2015. Even as per the case status also,
Please.
it appears that the matter is settled. She submits that she has no instructions from the client considering the fact that the MC is already disposed of. This petition is dismissed as infectious.
Please.
Yes, next.
Number 64. Prashant is Santosh Vimani.
The matter pertains to grant of stage carriage permits to the private operators. The informed that the scheme itself has been modified by the government once again, and that modification is challenged by both the parties. Which is pending before the principal bench. The matter has already been heard, and for further hearing, day after tomorrow, the date has been fixed. If that matter is disposed of.
But anyway, whatever is the result of that, this has to.
Please.
We are awaiting the Lord's order from.
This is matter on 13th of, when is it coming? 13th of November. It is submitted that the connected matter is coming up before the principal bench. Yes.
Number 65. Is the Dharwad.
Earlier occasion, about to allow the petition, my lord, we directed to submission to pay the entire amount. They have not informed anything.
Let me just look at what has happened. At the request of the counsel respondent, this is matter after review.
They have filed IR number 6 in the petition, stating that I have not paid the arrears of the 125 proceedings, 125 recovery proceedings, and they have gotten stay in the MC and the declaration.
That's what I said. Now, if you're not paying whatever it is, let's not relegate the parties to several forums.
But it is not pending.
No, you do not want to, honor an order passed by the court, and at the same time you want an order from the court. How can there be?
Maybe. Statutory remedies there. They can.
Let's not. That's the whole purpose of it. That's the whole purpose of it. That's what the Supreme Court said. Why should we relegate the part? And that too between the same parties. Between the same parties. You want divorce, you will not pay the maintenance.
But the second one is for a declaration.
What declaration?
For paternity.
Whatever it is, that's a matrimonial dispute. It's not different. It's not different. We will not relegate the parties to different forums. You have to comply with the order, or else I have passed n number of orders on that.
But that was with respect to pending
Anything.
24 maintained.
Anything.
But this is
Under
151.
151, under 151, court has the inherent power for doing complete justice.
Yes, but there is a remedy, statutory remedy is there. Without exhausting that remedy,
What is a statutory remedy?
they can file recovery proceedings under 128 of CRPC. And that they have filed for us. Now they don't want to pursue that, they want to come to this court and use this court's
First of all, where are your bona fides? Why don't you pay the money? Why should without paying any amount as granted by the court, why should the court hear your matter?
One submission. What happened? He government is all the while I was taking a warrant, my lord. In MC case, I had to cross-examine him, my lord, in the witness box. You know, warrant is on him, my lord. This is the situation in the same court, my lord.
What instructions you wanted to get on the last occasion?
Not, I could not contact my client first.
But whether you contact your client or not, I think the order is like the writ petition has to be allowed.
But with respect to that, I have.
No, that you have already advanced your argument.
I have specifically, I have.
I understood your argument that he has a remedy of filing execution. He has filed it. So that is what is your submission. That I understood. Apart from that, you want to say anything? On that, the court will pass an order. Court will tell how your submission is not tenable.
This would also cause a huge pendency to the huge load to this court itself.
No problem.
Other
The court has all the time.
Statutory remedies.
So many frivolous litigation court is taking care of. It is not frivolous at all. It's not a statutory remedy. It is between the very. That's not. You can't statutory remedy, alternative remedy. We are not under Article 227. I mean, on a 226 issue, you are not saying that. No, he has filed a petition before the court. Court said he is questioning that order before this court. Now, this court has to look at whether the order passed by the trial court is right or wrong. In the opinion of the court, it is a wrong order. Court has the power under 151 to exercise the discretion.
Even before the trial court, the citation that submitted it was with regards to pendent maintenance.
151 is not about pendency light. 151 is a provision available to the court. It can exercise in any of the cases. Please come. Where is the order?
Please number 14.
Agreed with the orders passed in IN number 7 in OS number 44 of 2019, dated 16/9/2021. The defendant wife, defendant wife is before this court. The wife had filed the present IA, that is I number 7, under section 151 CPC, to stay the further proceedings of the case till payment of the entire maintenance by the plaintiff husband.
Page number 78.
The court, while dismissing the application, observes that there is no dispute about the fact that defendant is a legally wedded wife, and since March 2015 they are living separately. And as per the order dated 5/12/2019 passed in Criminal Miscellaneous number 33 of 2016, a sum of ₹7,000 per month is granted to defendant number 1, and a sum of ₹3,000 is granted to defendant number 2 as maintenance. And according to the wife, a sum of ₹4,85,000 is due towards arrears of maintenance to them from the husband till 27/7/2021. And on one or the other reasons, the plaintiff has been avoiding to pay the maintenance. The court observes that basing on that ground, the further proceedings of the case cannot be stayed till payment of the entire amount of arrears by the plaintiff to the defendant. As there is no specific provision under the CRPC for recovery of the arrears of maintenance as against the plaintiff, and instead of taking proper and necessary legal steps, the defendant has filed the present application. The court observes that the defendant has already filed a petition for recovery of arrears of maintenance in criminal miscellaneous 47 of 2020, which is pending consideration. And the maintenance is granted under the provisions of 125 CRPC and not under the provisions of the Hindu Marriage Act. And the remedy available to the petitioner is under the provisions of CRPC for taking coercive steps. Hence, the court felt that this is not a case where the court will exercise a jurisdiction under section 151 CRPC, 151 CPC. Next paragraph. When counsel appearing for the petitioner file submits that the husband, being a government employee, is evading to pay the maintenance. At one stage, he is not complying with the orders passed by the court. And on the other stage, he wants the court to proceed with the matter. When counsel submits that under section 151 CPC, the court has inherent power to pass an order which the court failed to exercise the discretion vested with it. Next paragraph. When counsel appearing for the respondent husband submits that the maintenance was granted under 125 CRPC, and if the maintenance is not paid, he has the remedy available under the provisions of the CRPC. He submits that had been a case that the interim maintenance is granted and the husband had failed to pay the maintenance, then the court can invoke the provision under 151 CPC and can stay the proceedings. But the same will not apply to this particular case. And the court had rightly not exercised the jurisdiction under 151 and dismissed the application filed by the wife. Anything else? Filed by the wife. He submits that no interference is called for from this court. Next paragraph. However, the counsels on either side produce the material on record. The disputes are pending between the parties. The present suit is filed by him questioning the paternity of the child. The court under 125 CRPC has already passed an order granting maintenance to the wife. The husband had failed to pay the maintenance and the recovery proceedings are initiated as well. The husband had filed a petition under 151 CPC asking the court to stay on further proceedings till the husband pays the maintenance. The contention of the counsel appearing for the respondent that had it been in the very same proceedings, the court would have got power under 151 CRPC. But as these are arising under the CRPC, the court has no power. The said argument has no legs to stand. When the court has arising out of the matrimonial proceedings, either under 125 CRPC or the suit that is filed as also before the family court, as it is also arising out of the the matrimonial proceedings, where when an order that is passed by the court granting maintenance, the husband is not, husband cannot say that for implementation of the orders passed by the court, the wife can file recovery proceedings. But in the very same, in the proceedings arising out of the matrimonial disputes, that it has to be dealt with independently. The courts cannot permit the litigants to permit the litigants to take the process of law for a right. When the husband has had an order which he has not questioned, which has not attained finality, and when he is not paying, the court should have exercised a discretion and should have granted stay in the proceedings which are pending between the parties. That is in OS number 44 of 2019. That's a substantial justice and that's the inherent power the court has under 151, and court ought to have exercised the same. In that view of the matter, the petition is allowed. The order passed by the court the impugned order dated so and so is set aside, and there shall be stay of all further proceedings. In OS number 44 of 2019 till the husband pays the entire maintenance entire maintenance that is pending, the pay that till the entire amount is paid. Accordingly, petition is allowed. Yes, next.
65.1 is also same.
65.1 is also.
In the NC petition, divorce petition he has filed. In that petition also I have filed that.
In this, only instead of OS, it would be MC, seeking divorce. Yes.
Number 66, 67, 68, number 69. 69,
Negotiation is going on. 1 week time.
Girisha Sulamani.
My lords, in this case, I appear for the respondent, my lords.
What he says, negotiations are going on.
My lords, as per the records, my lords, this case has been disposed of on 25 January 2024, my lords.
25
January 2024, my lords.
Counsel for the petitioner submits that.
My lords, I am for the respondent.
Submits that the main MC is disposed of on 25/1/2024. As such, this petition has become infructuous, dismissed as infructuous. Yes, next.
Morning, I have instructed that judgment. Morning, I have instructed that the petition of the respondent is dismissed with value. So I'll just get the certificate of petition necessary.
So far as my submission is concerned, I have to get information also.
The request of both the parties, this is marked on 13th of November. 15th of November. Yes.
71 address, number 72.
Petition is challenging the execution proceedings not initiated by the respondent. Why?
Who appears for the, this is 71 or 2?
72.
Where is the respondent? How much is the intermaintenance?
5,000 has been awarded. What happens now? 5,000 has been awarded in the year 2018. Thereafter, not to recover the said assets, not be filed, not criminal miscellaneous. In the said criminal miscellaneous, not a part amount has been paid on some dates. Not. Thereafter, matter was settled before the local. That they agreed to stay together in law. Accordingly, not the matter was settled as closed law. And thereafter, in the year 2022, not she has taken her cash not, and since not the petitioner is staying in Gangavati, she said that not I will stay in Ballari. He not taken a house on rent and provided each month maintenance. Not he used to stay along with her. And as he is a mechanic and doing rice mill, not he used to go up and down. Not. Thereafter, in year 2022, not the director filed for another criminal miscellaneous under section 125(3) of CRPC law, seeking arrears of maintenance of 4 years not since from 2018 till 2022 not. That person not in that person not have been challenged.
Counsel for the petitioner is present. No representation for the respondent. This is matter as part for tomorrow.
Interim order candidate.
Interim order earlier granted is extended. Yes.
I want to have some documents that to show that during pendence of the proceedings.
Filed by way of a memo.
Along with the memo. No.
Yes, filed in the registry, it will come tomorrow.
So therefore, the respondent.
73. What about this?
This is my lord's the petition. Petitioner is challenging the order passed by the London Family Court. In setting aside the my lord's ex parte order filed by the my lord's wife. And
Counsel for the respondent is present. No representation for the petitioner. Pose this matter tomorrow as partner. Any interim order is there in this? Any interim order, if at all, any orders are there?
That is made absolute. Interim order made absolute until further.
Yes.
74 and 75. Abdul Ahmad Empire. 75. Chitana Birch.
excuse election.
What is this?
Wherein the petitioner is filed the petition challenging the order passed by the family court election, wherein he sought for the custody of the child election, and the same came to be allowed. Thereafter, he filed the execution petition to take the custody of the child.
No representation for the petitioner, counsel for the respondent.
We have already challenged the order before the division bench ownership, and there is a stay ownership. So he can seek this remedy before the division bench.
That's what. No representation, post this matter for dismissal tomorrow. 75 for dismissal.
Number 76. Page 5.
No representation for dismissal. No representation for dismissal tomorrow.
Number 77 items, 78. SC Raymond.
Same order. For dismissal, day after tomorrow.
Yeah. 6. Number 79. Vijay Malali.
Vice petition is filed by wife in-laws seeking enhancement of interim maintenance, and second petition filed by the husband, reduction of interim maintenance.
Where is the counsel?
Some Kalwa.
Counsel for the wife.
Yes.
Counsel for the wife is present. The counsel for the respondent, the husband is not present. This is matter as parted tomorrow.
Thursday.
Huh?
Thursday.
Thursday, as parted on Thursday.
Number 8. Number 8. Prashant Escardova. Possible.
This petition does not survive for consideration. Main matter is disposed of.
When is that?
25T.
Let counsel for the petitioner submits that the main petition itself is disposed of on
25T.
where do you get that? On 25th October 2024. Accordingly, the petition is dismissed as instructions. Yes, next.
Number 81 items, number 82. Vishnu Hegde.
Yes. Respondents are served.
Yes, Melody, she is represented also.
Oh, what is the name? Alam M.
Alam
Kadakadi.
See, counsel of the petition is present, no representation for the respondent. A list is marked tomorrow as part of.
Number 83, 84 items, number 85. Is it correct?
Huh? It's already adjourned, I think, in the morning.
I'm appearing for
84. You can file in the registry. File in the registry. Yes, 85.
Canada, I'm appearing for proxy consumer now. Kindly with 2 days.
Why 2 weeks?
2 days, Canada.
They will have day after tomorrow. At the request of Thursday. At the request of land counsel for the petition, this is matter on Thursday. Yes.
Partner matters, number 86. Santosh Kumar, Vijay Nayak.
On behalf of respondent, I request tomorrow, some inconvenience to the pay.
Tomorrow. Tomorrow at the request of land counsel respond. Yes.
Very much, number 87. Thank you very much.
The petitioners are wicked holders. They filed a suit 104/74. And the judgment letters are the vendors of the property.
No representation for the respondents. Counsel for the petition is present. List is matter day after tomorrow as part of this. Day after tomorrow. Not 87, 88.
Number 88.
No representation for dismissal tomorrow. Huh? You want it tomorrow? Not dismissal tomorrow.
Number 89, 89, 90, and 100. Number 91.
Commission inside. Will not come.
No representation for dismissal day after tomorrow.
Number 92 urgent, number 93, 92, 93 urgent. 94, seal number 94, Satikan Purwala, G. Narasimha.
Counsel for the respondent is present. No representation for the petitioner is for Mrs.
Mediation,
Huh?
refer to mediation.
He has to come for that. For dismissal day after tomorrow. Tomorrow itself will come. Yes.
Seal number 95, urgent 96, Pallavi Mohan, Palekar.
No representation for dismissal day after tomorrow.
97 urgent, seal number 98, G. Narasimha.
97 they asked for time in the morning. They said they have informed us. 90? 92 is adjourned in the morning itself. Yes.
98, seal number 98, Narasimha. IC Party.
Right, yes, up to the trial court. She is seeking evidence against her husband on the ground that he has made a false evidence without valid reasons. He has left the company of the husband or left two grounds for that, which is dismissed in that. So seeking to set aside that order.
Please come to the order.
Number 13 application. Reasons. Number 13.
Para number 13. 30.
One.
Read.
The petitioner is wife of respondent and the marriage is not in dispute. But according to the petitioner and the government, after marriage, within a few days, respondent and the other father rapidly physically also for component they have made a demand of 8 lakh rupees in cash and also for gold and silver and asked her to bring the same from her current account. The relatives of the respondent have instigated the respondent to demand dowry from the petitioner and the parents and the respondent also got her and the staff of the petitioner instigated to bring rupees 8 lakh from her current account. So one of the allegations she makes against the respondent on the ground for filing this petition. She was making a dowry demand from his family member. The second ground is that she has added to the alcohol, she has company of another woman and has she caused present to the petitioner and there is a danger to her life. This is the second ground for her to file this petition. According to the petition, there are only two grounds which she has to establish and present that the respondent has willfully neglected and refused to maintain her. To prove the same, she got examined herself at the and this is that she married and respondent on 31st April 2015 job and at the time of marriage, 13 lakh gold, 1 piece silver and 2 lakh cash was given and 8 lakhs was spent and the marriage was performed. It is evidence that she went to the house of respondent and met sought her marital life and she was paid by them properly only for a few days, but the harassment started within no time. It's her evidence that respondent was suspecting her character and was finding fault with anything she does in the house. This evidence given repeatedly given for a respondent was suspected and has not been stated in the petition anywhere in file number 129. It is really or Second, in her evidence, without any pleadings in the petition, she further discovered there was a frequent demand of dowry by the respondent and his family members, and they were inside such a way because he came from a poor family. She also reports that the relatives of the respondent had suspected her and they also assaulted her. It is stated that by her that all harassment was given to the respondent with an intention that she should
It appears that the court was dealt with like a criminal trial.
This is a similar case.
Huh?
Before filing this entire case, we are trying to before the Supreme Court Dharwad, where a decree was passed. During the pendency of the petition,
No, a decree of divorce is already granted. What is on what ground the divorce is granted? On desertion.
we have filed an appeal whether say has been granted.
Then let this be pending. Let this be pending. Because when there is a once it's 125 CRPC, already a competent board has given a finding that we have deserted her. Let's see till the other part. Which year is that? Which year is that? That appeal never filed. Which year?
2022.
List this matter after winter vacation. Yes.
Number 99. Question what is must be nine? Must be nine.
Lord, I appear for the Lord respondent.
Where is the counsel for the petitioner?
Lord, I think
No representation for dismissal day after tomorrow.
Lord, I have filed a Lord application. I have filed application seeking withdrawal of the amount in deposit. 2 lakhs is not deposited by the petitioner in view of interim order passed by this court. I may be permitted to withdraw that amount.
An application is filed. IA number 1 of 23.
Yes, ma'am.
There is no representation on behalf of the petitioner. Let counsel for the respondent submits that he has filed IA number 1 of 23 to withdraw the maintenance amount deposited by the petitioner, considering the submissions and perusing the material law department. I number 1 of 2023 is allowed. The petition is permitted to. No, I think it's not IA number 1 of 20.
IA 1 of 24.
IA 1 of
2024.
are permitted to withdraw the amount. Yes, according to IA's order, post the RTFC for dismissal on Thursday.
Please.
Yes. This also on Thursday for dismissal. No representation on behalf of both the parties. What has happened to 76? Tomorrow it's coming. Tomorrow it is coming. No, respondent is there. Oh, no, nobody is there. If you can take out that file.
Page 48 was order and coming to the court.
Yes. What is the order?
The court below has passed an order and memo models. I have filed a memo stating that in recovery procedure, I have totally amount deposited before the court and excess of rupees 7,000 as on the date of the filing of the memo models. But the Governor court comes to conclusion that what earlier interest was paid, that is including along with that models. I have filed a memo. But the court says that at least 48 lots. Page 48.
48.
As per the final orders in the main petition, the respondent was liable to pay 2,500 from the date of petition till the second petitioner attained the age of majority. As such, the liability of the respondent was the second petitioner from the date of petition till the disposal of the petition 1,10,000. The interim maintenance was paid, not ordered to be deducted from the same amount. Hence, the respondent is liable to pay the said amount 1,10,000 despite having paid the income maintenance. So Tenancy Act claim was claim number 11. I have filed a memo for calculation. I have paid of that out of 1,10,000, 78,000 has been paid.
Where is your calculation memo?
Page 11.
Page number?
11. Make it big. Here was income maintenance awarded by this court from 11/4/2018 to 30/12/2021, that is 44 months, it's amount of 88,000. Here we also this one has paid about 78,000. Here the remaining balance only 10,000. And after the date of notes, the arrears of the amount of 22,000 was there. So totally 32,000 was remaining. So after the passing judgment from 13/12 to 13/2/2023, I have to pay the filing of memo notes. That's 35,000. And part of the petition was allowed.
No, I'm not able to understand one thing. Interim maintenance already paid by the respondent is 78,000.
Yes, ma'am.
And you say balance amount to be paid is 10,000. Then no. Then when it comes to serial number 6, you say less amount paid by the respondent to the petition number 1, 74,500. What is this petition?
Plus the total amount again serial number 2 78,000 paid. I told the second serial number 4 35,000 was paid. Out of 10,000.
Where from I can understand that.
Please. But what the court was that interim maintenance what was paid, that cannot be.
Now the difficulty is, as far as that is concerned, court will make an observation.
Please.
But what is the amount and all, there is no clarity here.
No, is very clear.
No, then I'll record like this. As far as the interim maintenance is concerned, which is already paid, has to be deducted.
That's right.
And above all, if at all there is any other amount, the respondent is at liberty to file an appropriate application. That I will record.
That has to be done, but here was.
No, that's what I'm saying. Please understand. The court will not go into any of the calculation. Court will say that as far as the interim maintenance that is paid by him has to be deducted. Has to be deducted. And after deducting, any amounts has to be paid by you. It has to be paid, and the respondent is at liberty to recover those amounts. Please come. Agreed with the orders passed in criminal miscellaneous number 50 of 2022, dated 13/3/2023, whereby the court has given a finding that the petition herein is still due of an amount of rupees 45,000 till 11/4/2023. The petition is before this court. Learned counsel for the petitioner submits that the court has not deducted the interim maintenance that is already paid by him. He has drawn the attention of the court to the order wherein it is observed that as per the final orders in the main petition, the respondent is liable to pay 2,500 from the date of petition till the second petitioner attains the age of majority. As such, liability of the respondent towards the second petitioner from the date of petition till the disposal of the petition was rupees 1,10,000. The interim maintenance paid was not ordered to be deducted from the said amount. Hence, the respondent is liable to pay the said amount of rupees 1,10,000. Learned counsel submits that the court went wrong in giving such a finding. He submits that when he has already paid the interim maintenance, when the court has ordered the maintenance per month, the same is liable to be deducted from the amount that is already paid. This aspect was not considered. No notice is served. Which is this case? What officer? Which case is this? Serial number? 76. Though the notice is served on the respondent. Though notice is served on the respondent, there is no representation on her behalf. This court has produced the order passed by the court. The court observes that there is no direction to deduct the amount paid towards interim maintenance. There cannot be any direction from the court when the dependency of the proceedings, when the petitioner has paid the interim maintenance, and when the final amount is fixed, by calculating that amount, this amount which is already paid has to be deducted. In that view of the matter, this court is passing the following order. 1. The interim maintenance paid by the petitioner shall be deducted from the outstanding amount, from the total amount. Number 2, if after deducting the interim maintenance, if still the petitioner has to pay any amount, the respondent is at liberty to recover the same. 3. Accordingly, petition is disposed of.
Number 78 also. After tomorrow for dismissal.
78? You're for the petitioner. Day after tomorrow, not the dismissal. Day after tomorrow, list this matter. Day after tomorrow, at the request of the counsel for the petitioner. Send.
ಕೆಲವೊಂದಷ್ಟು ಬಂದಾವಲ್ರಿ ಈಗ ಬಂದಿದ್ದು ಮಾರ್ಕ್ ಮಾಡಿರೋದಾಗ ಬರ್ಲಿದ್ದು ಅಷ್ಟು ಅವು ಡೇಟ್ ಫೈಲ್ ಬೇರೆ ನಾಳೆ ಡೇಟ್ ಇದ್ದಿದ್ದು ಅಷ್ಟು
ನಾವು ಅರ್ಥವಾಗಿ ಹಾಕೊಂಡು ಫೈಲ್ ಹಾಕೊಂಡು ನೋಟ್ ಮಾಡೋದಂತಂದ್ರೆ ನಾವು ನೋಡೋದಿಲ್ಲ ಮಾತಾಡೋದು ನಾನು ಗಮನಿಸ್ತೀನಿ ಫೈಲ್ಸ್ ನೋಡೋದು